My friends, I just pressed the Let's Go Live button. It's a beautiful Monday. We got a fresh new week ahead. And so let's make sure there's no cobwebs on those tubes. Let's make sure they connect themselves all across the fruited plain of the internet. Before we go ahead and get started, it looks like we are alive and well on the YouTube, on the Telegram. Hopefully Rumble's working. And locals as well, kicking over any minute. Let's go ahead and get started, my friends. It's time to hit the show, starting now. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Trump and Fani. Because, man, she is getting told today big time by Trump's attorney, Steve Sadow. We're going to talk about that. But to start the show off today, we are going over to Florida. Remember, last week we had a big drop. Trump's defense dropped, I think, like 7 different motions, many of them to dismiss the case in its entirety. And last week we read through the motion to dismiss based on presidential immunity, which was good. And the word is called immunity. Not whatever I just said, but presidential immunity. And the other one was about the disqualification of Jack Smith. Of course, those were 2 spicy meatballs. And we had those covered last week, but we're not done yet. We have a new one to unpack today. And this one is the motion to dismiss based on the Presidential Records Act. And I am very excited for this one because for years now, we've been screaming here about how Trump, as the president, has the power of the opinion clause, which is in the Constitution, which says the president is entitled to the writings of his executive. And that's what happened here, okay? And so Congress and Deborah from NARA, the National Archives, they get called out in this filing specifically because they deserve to be, because NARA, the National Archives, the head librarian of the country, is not the position that's above the president, okay? No matter how much they try to tell us that, she's not. So we're going to go through that filing. It's very good. And I'm excited to get to it, as you can tell. Then we're going to hear from CNN. They're saying, oh no, exactly what we talked about last week is that now we've got a conflict between the circuits. Isn't that fun? So in Florida, we have a question about presidential immunity, and that might go opposite to what happened with Judge Chutkan. Judge Chutkan saying there is no presidential immunity because of Trump. Not really a good legal basis for it, but that's what they're saying. And the same thing with the DC Circuit Court of Appeals. They're all upset about Trump. And so CNN is saying, you know, these two might be pitted against one another. And so we'll see them tell us about what things are looking like in terms of the trial calendar and how that will be unfolding here in the near future. And then in our second segment, we're talking about Fani Willis because, my goodness, on Friday, we talked about those cell phone records. We read through the full filing from Steve Sadow and, of course, Middlestat, who was the guy who submitted or gathered a lot of these records. And now Fani is replying to that. And Steve Sadow, Trump's attorney, they also replied to her response. And so what's going to happen today is we're going to go through and see how angry Fani was. Remember that the affidavit from the expert, who's not an expert, who's just a summation witness, really, he said that these two lied to us. I know you're shocked, I know. But apparently Nathan Wade, who told us that he showed up at Fani's condo less than 10 times, apparently it's like more like 35, oops. And they said their relationship started in 2022. They swore to that in a court affidavit. Turns out these two were texting, and there was definitely a booty Fani call going on there. You know, the 11:30 phone calls, and then he goes over there, and then he leaves at 4 in the morning. We all know what's going on, okay? They're not reviewing their legal memoranda to prepare for their pretrial conferences, okay? They're indicting each other, and they're indicting each other repeatedly. It's not good for us to think about. But Fani then objected to this. And man, this is one of the most wild filings we've seen in some time. It's very rare that you're going to hear from a prosecutor who's literally screaming at the courts in their court filing, okay? Not only is Fani pressing the cap locks button, okay, which she's going to do hard. She's like, caps lock it. He's like, I can just press the shift key. She's like, I want it capsed. But in addition, we have it being bolded and underlined as they scream at us about racial and gender bias. Okay, it's coming up. It's really incredible. Yeah, I can't wait to share it with you. It's amazing. And so she's screaming. She also put on there her calendar. Okay, her calendar event is coming up. Oh, these people don't actually even work. They don't even do anything other than go on cruises and celebrate themselves and then indict their special prosecutor. So we're going to go through it. We're going to see what's on Fani's calendar. And then the entire saga got obliviated because Steve Sadow filed a response. And the crux of Fani's objection is like, these phone records are really destroying my entire case and my career and my future. They might even destroy my freedom because I lied to the court. Oops. And all of that is something they want to object to. And they're saying that these records are just not legitimate. They're not from a qualified expert. So they're trying to get it thrown out on a technicality. But Trump's team came back and then obliviated that. Saying, he's not an expert witness. We're not trying to get him here as an expert witness. As you know, we didn't break the law to go get these records. We just got a subpoena. And we use the same technology that your office uses. So it's all above board. Fani, you don't like it. Well, that's too bad. Maybe you shouldn't have indicted your special prosecutor. And then 11 Alive today, we're still waiting to hear if anything came of this. But Terrence Bradley apparently was meeting with the judge today. And that's curious. We don't know what happened there or if there's going to be any filings or whatever. But remember, Nathan Wade also did not want this to happen. He said, you can't meet with him. You can't talk to him about anything. The judge evidently said, sorry, denied. And we are meeting, and that happened today. So we'll see what 11 Alive said about that. Local news entities there in Atlanta. And so as you can see, my friends, we got two nice segments to attend to today. We are glad and grateful you are here and with us. I hope you had a beautiful weekend and your week is off to an amazing start. You know, Mondays, hopefully you got all those to-do list items checked off there, getting started on the list, knocking them out. We had a tremendous weekend doing our Saturday stream with our friends at watchingthewatchers.locals.com. We cracked into some of the Fani stuff a little early. And so if you want to come join us when we have these conversations, watchingthewatchers.locals.com is where you can join us. We do streams in the morning. We already had a great stream this morning talking about, what did we talk about this morning? Oh, mostly Biden's and the Italians mocking him. Shout out to our friends in Italy, mocking our president who can't talk or speak or walk. But we have a lot of fun there, watchingthewatchers.locals.com. Come and join us on that platform. We also have robertgovea.com. So if you want to grab any of the PDFs we're about to go through, that's where they are. We post them there after the show with the red line so you can see exactly what we covered. We also have a newsletter there that you can sign up for. That way you get all this stuff delivered to your inbox. And when it comes to your inbox, you have our full permission here to forward it to every single person you've ever met in your whole life and tell them to subscribe to our newsletter and channel and show. Thanks. We also have watcherlodge.com, which is our newest community platform where we're focused on sovereignty and self-development. We have a lot of fun stuff cooking over there. Last week, we did a food sovereignty workshop and a development project with our friend Michael Voltz. This week, we have political Zen wellness with my friend who is awesome, Zen Wellness Master Jason Campbell is coming by on Thursday. So mark your calendars, 9 a.m. Mountain Time, 11 a.m. Eastern Time. It's free. Come and sign up at watcherlodge.com. Links are in the description below. And we're going to zen it out, my friends. We're going to clear our minds of all this mental turbidity so we can be a little bit more productive, more focused, a little less stressed, and more effective people in our daily affairs. And so come check it out, watcherlodge.com. We got a lot of fun stuff cooking over there as well. All right. And now, my friends, without any further ado, let's get into business. It's time. Donald Trump files another motion to dismiss his case in Florida, the classified document saga, Judge Eileen Cannon presiding, and Trump submitted a whole slew of these motions, and we've covered several of them here already, including the motion to dismiss based on presidential immunity and the motion to dismiss because Jack Smith is illegitimate. We're very excited about those two working their way through Cannon's court, but now we have another one, and this one we've been paying close attention to as well. What about the Presidential Records Act? You've probably heard Trump had these classified materials, and some people say, well, maybe he declassified them, so they're not actually classified. But there's a whole nother concept. What if the president just says, those are my personal records? Okay, and I'm the president, so I get to make these decisions. Somebody who's questioning me about whether these are presidential records or whether they are personal records would put them above the president, would put their discretion above the president's, which is obviously insane. But that's what they tried to do with Trump. They tried to put Nara, Deborah Stidel Wall, in a position above Trump to say the head librarian can decide and tell Trump what is true. Presidential records got to stay with the government, but if it's a personal record, it can go with Trump. And our point here for ages has been that the president has unfettered right to access to those documents. It's in the Constitution. If they don't like it, they can change that, but they haven't done that. And any other congressional statute that says, oh, my classified or whatever they say, I don't care. It is a statute that is subordinate to the Constitution. And if you put some other entity above the president, it topsy-turvies the whole Constitution. So now here is what Trump is saying, referencing many of these same arguments. Let's get right into it. The motion to dismiss the indictment filed in the classified documents case by Donald Trump, citing the Presidential Records Act. Filed in Judge Cannon's courtroom, West Palm Beach Division, and this is United States of America versus Trump, Walt, and Carlos in Florida. Here's what they tell us. Dear Judge Cannon, President Donald Trump respectfully submits this motion to dismiss the superseding indictment because of the Presidential Records Act. Let's get into it. First, the Presidential Records Act, the PRA, it conferred to Trump unreviewable discretion to designate the records at issue here as personal. Bill Clinton can do it, Trump can do it. Now, as such, because the Presidential Records Act gives him that power, Trump's possession of those records, all those 32 documents that are in the indictment, was not unauthorized. If they're personal, they're his, they're not unauthorized. Counts 1 through 32 say it differently, but they're wrong. And second, even if there was some sort of violation of the Presidential Records Act, Judge Cannon, the PRA, if you look at the act, it's exclusive remedy for a records collection effort to go get those back from Nara, Deborah Stidel Wall, who initiated this whole thing. It's civil in nature and it forecloses criminal investigations. So you just civilly go get this stuff back. You don't prosecute the man. Footnote 1. And they say, by the way, Trump also reserves the right to supplement this motion and add a bunch more to it if we want to. Saying, therefore, Judge Cannon, as with counts 1 through 32, and recall that each count from 1 through 32 was just a different document. Okay, that's it. So document, document, document. And many of them are briefings and, meaningless stuff. Maybe it was important on the day of the briefing. It's not important 5 years later when all the stuff has already happened and everybody knows about it. The remaining counts charging Trump then, so if counts 1 through 32, if he was in possession and they were not unauthorized, then all of the following counts about obstruction and conspiracy and all the other garbage, then it all fails to state a claim because he wasn't in illegal possession. And so accordingly, they say the whole dang indictment now gotta go. They say, all right, Cannon. First of all, the special counsel's office concedes that the genesis of this case, their own statements, it dates back to at least, quote, the tail end of the Trump administration itself. In other words, Trump was president still. The office in Jack, the illegal office, alleges that Trump, here you can see the word caused is italicized. Trump, when he was the president, caused, all right, so Trump did the bad thing, caused scores of boxes, many of which contain classified documents, to be transported. He's the root person. Now, the superseding indictment from Jack also makes clear that this decision and the related transportation of these records occurred while Trump was still in office. So think about this, right? If you caused something to go somewhere, that means it's emanating from your presidential power, right? You are the deciding it stays or it goes. What do you decide, right? So we're going to come back to that. Now, they say that Trump caused boxes of records to be packed and to be shipped in January 2021 as he was preparing, okay, again, so meaning he was in the presidency, preparing to leave. So all this stuff happened as president. So President Trump departed the White House prior to 12 p.m. on January 20th. They said he's never going to leave. They tell us he's never going to leave again. If you elect him, it's the end. He'll never leave. It's like he left last time, you weird freaks. After you just said he insurrected the country, he packed up and left. Nice. And as such, all of these allegations are decisions concerning the documents at issue while he was commander in chief. So it's all within the power of the presidency because he was in the office preparing to leave. So they give us some background here. All right, what is the status on a motion to dismiss? What's the standard? So Judge Cannon, here's some authority for you. If you want to dismiss this indictment here, you can. It says an indictment may be dismissed where there is an infirmity of the law in the prosecution. So when Jack Smith is charging a crime that's not really a crime, you can dismiss it. A district court, like you, Cannon, may dismiss an indictment when immunity or double jeopardy or jurisdictional issues are implicated. And an indictment that requires speculation, you have to fill in the gaps on a fundamental part of the charge, it's insufficient. So you got to say what you're charging, and it's got to be legitimate in the indictment itself. They go back. They say, let's talk about the Presidential Records Act. They say, beginning with George Washington, presidents of the United States have, without notable exception, treated their presidential papers as personal property. We talked about that in a case called Nixon versus United States back in 1992 in Washington, D.C. In 1974, a lot of presidents take their documents. Even Washington did it. Congress, back in 1974, they enacted the Presidential Recordings and the Materials Preservation Act of 1974. Because they were based on a concern that Nixon might destroy records related to Watergate. The controversy over Nixon's records and whether the act interfered with his right to privacy in his personal records led to the passage of another act, the PRA. So some history on that, right? Nixon, Watergate happens. Congress says, oh, this dude deleted a bunch of recordings out of the White House. That's not good. So they pass the first version, Presidential Recordings and Materials Preservation Act. Like, wait, that's way too overbroad. It's going to gobble up everything from the president. So Congress modifies that. 4 years later, 1978, boom, we get the Presidential Records Act that we live with now. Now, in passing the Presidential Records Act, Congress, this is from a case called Armstrong versus Bush in the D.C. Circuit 91, says when passing the Presidential Records Act, Congress was also keenly aware of the separation of powers concerns that were implicated by legislation regulating the conduct of the president's operations, right? Because you got to be very, very careful there. If Congress can just legislate what the president has to do or can do, then is Congress the president? That's why we have a separation of powers. We don't want one branch gobbling up too much power. And when Congress does that, the president tells them to get back. Flexes. This is my power. So Congress, therefore, sought to assiduously to minimize outside interference with the day-to-day operations of the president and his closest advisors. Now, Congress also limited the scope of judicial review, so the courts can't dig into it, and provided little oversight authority for the president and the VP's document preservation decisions. You know, because, of course, they're the president and the vice president. Now, all that was perfectly normal until Trump came in. And they're like, well, he's only kind of the president, and he doesn't have certain things that all the others had. They say under the PRA, during a president's term in office, the president shall remain exclusively responsible for custody, control, and access to the presidential records. So when Trump's in office, it's his. The use of the word shall often denotes mandatory obligations, but what the president must do is exercise his discretion, and the rest of the text calls for exercise of considerable judgment, more case law. Now, this includes, they say, the sole discretion, meaning Trump, not Nara or Deborah. Sole discretion, the law says this, 44 U.S. Code 2203B, also cited in Armstrong, says the president has the sole discretion to categorize materials as presidential records or personal records. So if they're personal records, the argument is they're not inside the scope of Jack Smith. He can't charge Trump for those. Now, they say reasoning that the Presidential Records Act accords the president virtually complete control over his records during his term in office. They continue. And this comes from a Judicial Watch case. Remember, our friends over at Judicial Watch, they sued Bill Clinton to try to get this stuff, and they protected Clinton. They said, well, if it's his decision, he's the president, you know. The PRA does not confer any mandatory or even discretionary authority on the archivist to classify records. Oh man, Deborah's not happy about that. And she's the one who started this whole thing against Trump. So there's no discretionary authority to decide for them what's presidential or personal. No, the responsibility is left solely to the president. Upon conclusion of the president's term of office, the Presidential Records Act, 44-2203G, when the president's done, At the conclusion of the president's term, the archivist, in this case Deborah, quote, shall assume responsibility for the custody, control, and the preservation of and access to, look at this, the presidential records of a president, not the personal. So president, when he's done, he splits his books. These are my personal stuff. Those go with me to Mar-a-Lago. These are presidential records. Put those in your archives, Deb. Now, NARA's responsibility under that provision, it applies only to records, quote, that were designated as presidential records during the president's term. So when Trump splits those documents up, it only applies to what he specifically marks as records. Now, thus, the PRA assigns the archivist at NARA no role with respect to personal records once the presidency concludes. It's done. You're done. Now, courts may review guidelines, okay, outlining what is or what is not a presidential record to ensure that materials that are not subject to the PRA are not treated as presidential records. Again, a bunch of case law here. And they say here, in this case, this one considered judicial review, so whether the court was reviewing it. This case says, if you consider judicial review of policies and guidelines that exclude from the reach of the presidential acts, vice presidential records, that was that case. Here's another one that's considering judicial review, and so on. But, however, a close reading, this is Trump's team, of the Armstrong 2 decision suggests that the limited judicial review authorized by the D.C. Circuit left untouched another portion of Armstrong 1. So a second case came back, but it didn't impact the first case. The first case gave the president unfettered control over his own documents because it's the president. So now we get, so that's some background. Okay, these are the rules they say that are appropriate here and why the president has some power. And then we're going to see some more analysis and discussion as this applies to Trump. And so let's get this queued up here in one quick second. All right, starting now, the discussion. They say to Judge Cannon, all right, Judge Cannon, when we take all those rules and all those facts and apply them to our case with Trump, here's how it breaks down. First, President Trump's possession of all of the documents, those 32 documents in the various counts, it was not unauthorized under the law. Here's why. Trump exercised virtually unreviewable Article 2 executive authority to designate the records as personal, when, as alleged in the indictment, he caused the materials to physically be transported out of the White House while he was still in office. So he made the decision. Okay, he bifurcated them out into personal and presidential. President Trump was still the president of the United States when, for example, many of the documents at issue were packed, presumably by the General Services Administration, and that they were transported and delivered to Mar-a-Lago. Okay, so there were things happening while he was the president. All the things were being decided. The DOJ previously took a substantial similar position on behalf of NARA. So they cite us back to this Judicial Watch case versus NARA. So some time ago, Bill Clinton, remember, he left office and he had all these judicial records. We call them the Clinton sock drawer tapes. And Judicial Watch and Tom Fitton and those amazing people, they sued to get access to it. They sued NARA. They said, okay, you've got these documents, and why don't you have these materials? You have these, and they sued. So what did the DOJ say back then when they were protecting Bill Clinton and they didn't have Trump to worry about? So of course, they took a similar position the DOJ did when Bill Clinton was being sued. They said President Clinton, this is the DOJ, presumably classified the tapes as personal records by not transferring them to the National Archives at the conclusion of his administration. See? So a lot of people will say, well, Rob, or anybody making this argument, Trump didn't officially declassify anything, and he didn't classify them, right? We see this word classified, but we are talking about classified documents, but we're not talking about classified documents. We're talking about the classification of other documents, whether those documents are personal or presidential. And some of those records may have been classified, but that's not the classification that we're talking about right now. Hopefully that makes sense. So Trump He classified these materials. He left, and they're protecting him. They're protecting Clinton for doing much the same thing. But if NARA has the ability to make the president fill out a form, okay, then that's essentially the president, right? Because the power to access these materials, it emanates from the Constitution. Article 2, Section 2, Clause 1, I believe, which talks about the opinion clause power. And they're emanating it. It's the separation of powers concept. So as we continue, they say, President Trump then, well, and let's be clear. They're saying that, remember, Trump didn't officially fill out the form, and that's why they're not declassified, or that's why they're not classified as personal. Clinton did the same thing, okay, by not actively giving them to the archives. They, by default, just get automatically categorized as personal. And to have NARA or someone else come back in and override the president's discretion on that makes them the president. So this makes sense. Like, you know, Judicial Watch made a good effort, but this makes sense, right? If they're going to hold this standard here, it should also apply to Trump. But of course they're not. They're going to change their position, the DOJ themselves. They say President Trump made the challenged designations, the classifications, while he was in office as the constitutional superior to the archivists. Sorry, Deborah. The only reference in the entire Presidential Records Act to the designation of records as personal versus presidential also calls for the decision to be made by the executive and to be made during and not after the presidency. Now, that's also from Judicial Watch. The categorization of the records during the presidency, that controls what happens next. And the statute, it assigns the archivist no role in respect to the personal records once the presidency concludes. You're done. Thus, NARA has no authority over personal records, and the Presidential Records Act does not establish property rights for the United States. Those are our materials. And they say that Trump was obstructing. No, he wasn't. They're not yours. Referencing 44 U.S. Code 2203. This is what the law says. The law says, upon the conclusion of a president's term of office, NARA shall assume responsibility for the presidential records. They also cite the Hur report at 193. So they're referencing the Hur report. Yeah, even he says that. Says personal records remain the property of the former office holder. Those are all Trump records. So thus NARA does not have the authority to designate material as presidential records. They don't get to decide that, even though they really want to. The archivist also lacks the authority under the PRA to inspect presidential records or to survey their records management practices. That's from the Crew case. The court is left with the undeniable conclusion, they said this, that Congress vested almost no authority in Deborah, the archivist, and NARA over vice presidential records during a vice president's term in office. No authority. Couple footnotes. This is the Hur report. They say, look, even Robert Hur, he explained this when he found classified documents in Joe Biden's residence. I really like that they worked that in there. That's fun. The PRA, says Trump's team, also precludes judicial review of their record-keeping practices. So you don't get to come in here, Deb, and say, well, we don't like how you're keeping your books. It's too bad. You're not the president. Run for office. Become the president, and then you can fix that. Including President Trump's decision to designate those materials as personal. Permitting judicial review of the president's compliance with the PRA would upset the intricate statutory scheme that Congress carefully drafted to keep in equipoise, we don't hear that word often, important competing political and constitutional concerns. Because then the courts can just come in and just usurp everything, right? Judicial Watch can sue, and then Bill Clinton has to go get these personal records, got to go dig them out of his disgusting gutter drawers or wherever, and, you know, pull those out, rinse them off, and give them back over to Congress, right? Or to NARA if they had to do this. And that's obviously, like, the presidency is a powerful position. That's it, right? That's what our Constitution says. For a reason. And you can't just decide that these things no longer matter, right? There's a logic behind it, which is why we're seeing what has been done. Now, it would also be incongruous to permit judicial review of personal records designations in light of the fact that the president's decisions to restrict access to presidential records for up to 12 years, those are not reviewable either. And so even with respect to an incumbent president decision to destroy records while in office. So the president could even just torch these things. The PRA provides only cautious authority for the archivist and Congress to question those actions. You want to destroy the records? Go wild. That's from Armstrong. Precedent. So therefore, courts must steer clear of efforts to supervise the day-to-day operations within the White House. Otherwise, they're the White House. Even when a complaint presents legitimate concerns about an ongoing practice that threatens the preservation of or the public access to presidential records, you still got to stay out of it. When it comes to compliance with the PRA, courts have no jurisdiction to review their day-to-day. And that structure, here we go, is rooted in the separation of powers doctrine, which stands as a key basis for our system of government and rule of law. Yeah, but Trump's an even bigger threat. So we don't need separation of powers anymore. We can just have everybody do whatever they want, whenever they want, as long as it results in Trump not winning. And then, even though the rest of the country will be left in a smoldering ash heap of disorder where the Democrats control everything, that's okay. That's their playbook. They're happy about that. So moreover, it would demolish the notion of a chain of command, right? Because within the executive branch, if a NARA employee, including the archivist, was able to dictate to a president who embodies that entire branch of government how to handle the records. That's the point we've been screaming about here for I can't even say how long, like a broken record. Finally, I'm glad we see it in a filing. Deborah would be the president. Okay. Oh, sorry, Trump. You didn't get your library book due back in time. You're getting a penalty now. Criminal indictment. Sorry. What? For the president making a decision about his own documents? The chief executive of the whole branch. They say, sorry, you have to follow our forms. Fill out your forms and let us know that you're declaring these as presidential records and these as personal records, and then make sure you do it by Friday. Get out of here. Ridiculous. It would be insane to do this, but this is what they've done. We have a whole criminal case being prosecuted on this basis right now. They say the DOJ and NARA have adopted this position with respect to government officials whose last name is not Trump. Beautiful. Last fall, on behalf of the Attorney General and other federal government defendants, the DOJ, when they're not prosecuting Trump, they argued that the D.C. Circuit precedent in D.C. provides that courts lack jurisdiction to review day-to-day White House records management decisions under the Presidential Records Act. So there's other case law that says that, right? You don't have jurisdiction. They've charged them anyways. There was this case called Poindexter. During the Poindexter litigation, Mr. Reagan's personal attorneys and the DOJ, they repeatedly asserted that Reagan's diaries, okay, that contained classified information, he was writing in there a lot, were Mr. Reagan's personal property. Sorry, they're his. Okay, they're his diaries. That's what the president needs to do his job. The president has root power to the writings of his executive branch. It's in the Constitution, and so he can do something with that, right? If you don't like that, elect a different president who you have more trust with, right? We like to trust our presidents, even if MSNBC does not. So even though it is possible that the department lacked knowledge of all the facts about how Reagan stored his diaries, officials knew that Reagan contained classified information and that Reagan was treating them as personal records. And it appears that no one ever asked how the diaries were stored or ever made efforts to recover them. Well, that was a long time ago when we had a sane country. So during congressional testimony in March 2023, Jay Bosanko, NARA's COO at the time, oh gosh, can you imagine being a NARA COO? What a job. God. He testified in front of Congress somewhere. He said, if our general counsel were sitting next to me, he would tell me that I should defer to the president with respect to the implementation of the PRA, obviously. In other words, as expected and accepted, inferior officers did not challenge the president's handling of the classified information because they can't. That's why. Now, DOJ attorneys acting on behalf of NARA, they also pressed these points in a prior case in the Judicial Watch case involving Bill Clinton. Watch how the DOJ circles the wagons to protect him. There was a nonprofit, Tom Fitton and our friends at Judicial Watch. They sent a Freedom of Information Act request that was seeking 79 recordings that were from Clinton that constituted a verbatim record of President Clinton being the president. They said they're like, and I've read this, I think we've covered this here many years ago, where it was Clinton like actually talking about being president. Like he was doing presidential things that were being recorded. So like they weren't personal, you know, like he wasn't like sitting with Hillary talking about Epstein's Island or whatever. Like, gosh, you should have been there. It was crazy. You know, nothing like that. It was actually presidential duties. And so you'd think that those would be presidential records, right? No, sorry. The records contain some of the same types of information that the special counsel's office, they claim constitutes national defense information in this case. Yeah. So apparently back in Clinton's sock drawer tapes, there were foreign policy decisions like the United States military involvement in Haiti. Oh, yeah. You mean when the Clinton Foundation went down there and did Lord knows what with all those people? Yeah. So he took those records, foreign policy decisions with Haiti. Clinton and his side of the telephone conversations with foreign leaders. He kept those. Like that's all him being president. And you know, Haiti, that I think the earthquake down there was way after they were president, but very curious. Anyways, Clinton, his side of telephone conversations with Secretary of State Warren Christopher. This was about diplomatic impasses in Bosnia. Okay, like presidential actions, clearly. And details from technical forecasts that he received during presidential briefings. And guess what? In response to the FOIA, so Judicial Watch comes in there. They say, we need all those materials. We should get them. Clinton's a corrupt, you know, philanderer. We need to see these materials. FOIA, give it to us. They're presidential records. Let us see. In the request, NARA responded. NARA took the position they didn't even review the recordings, all right? That the requested materials, they just called them personal records of Clinton. Sorry, he defined them that way under the PRA. And that's in a letter. Now, NARA relied on the definition of personal records under the law. The definition excludes the functional equivalent of a diary or journal that was prepared or utilized or circulated or communicated in the course of transacting government business. So they say, it's interesting here, okay? That exception, it is clear that Clinton's recordings did not meet that definition based on the Judicial Watch pleadings and based on Taylor Branch's shout-out related book about the recordings titled The Clinton Tapes, Wrestling History with the President, published in 2009. But nevertheless, even though they tried to fit it into that exception, neither the government nor the court demonstrated any interest in disputing that position. They don't care. So they're like, look, this is back, you know, some time ago. They say, this is the president you're talking about. We're not going to get in there and just decide what to do with this. Like the judge is not the president, okay? NARA is not the president. You have to be insane to just say, we're just going to just topsy-turvy the whole thing. Now, in contrast to this approach of the DOJ and NARA in this case, right, things have reversed because it's Trump. There was no claimed rush to conduct classification reviews or a damage assessment. What did Trump take? What? They freaked out. Now, despite the apparently sensitive nature of the recordings that contain classified materials, it was beyond the imagination of those government employees that the recordings could or should be recovered through a subpoena and a search warrant. Bill Clinton didn't have his house raided, and they didn't go through Hillary's underwear drawer, which saved a lot of FBI agents many years of therapy. But rather, citing Armstrong, they've totally reversed themselves, okay? They would not go after Clinton at all. They wouldn't even think about it. Are you nuts? Judicial Watch, you want access to his record? Get the hell out of here. You guys crazy? But when Trump does it, it's like, whoa, we better call the FBI. Rather, citing Armstrong, the DOJ and NARA, they argued that courts cannot directly review a president's compliance with the Presidential Records Act. Weird. How come they can do it now all of a sudden? The government's conclusion followed from a fact that is essentially dispositive here. They say, the Presidential Records Act contains no provision compelling the archivist to assume responsibility for or to review that the president properly categorized and filed separately his personal records. So they did that voluntarily, essentially. they went after the Trump records sua sponte, on their own volition. Now, the DOJ and NARA, they also invoked policy considerations to support their non-reviewability argument by asserting that Congress gave each president complete control over his personal papers. Yeah, otherwise, someone else is in charge, in order to encourage presidents to keep and preserve those papers. Many hoped that presidents would later voluntarily donate those papers to the National Archives. Now, Congress was extremely concerned about future presidents and their privacy rights until they raided Trump. I'm like, well, obstruction. They said judicial review would be extremely intrusive, and such review would undoubtedly discourage presidents from creating any records in the first place. Now, at oral arguments, the court asserted, back during a prior case, that the law seems to vest, the court said this, right, in DC, the court seems to vest exclusive authority for saying this is personal on the president, which is the person who would know. That's what the court said. So the president is the only one who would know, the only one with the power, and the only person who can make a decision about it. In a written opinion that we have read, the court expressed serious doubts about whether former presidents and their retention of the audio tapes is a personal matter that is subject to judicial review. The judge, when she was reviewing Clinton, said, I can't even make a decision. If he says they're personal, they're personal. We can't look at it and make a different decision. Sorry. And they resolved the case on the basis that these claims were not redressable. So Judicial Watch can't get the records because they're not accessible. They're personal. Clinton said so. Now, as relevant here, the court, NARA, and the DOJ attorneys that represented NARA, they found it extraordinary and unfounded for Judicial Watch to suggest that the recordings could be recovered from President Clinton. They're like, what? It's the president. Get out of here. But that was Clinton. It wasn't Trump. So the court, they say, should preclude Jack and his office from further contradicting their prior positions. They already took these positions back in the Crew case and the Judicial Watch case. And so this all must be dismissed because they alleged inaccurately that Trump's possession of the records were unauthorized. No, it was not. And this indictment is impermissible judicial review of Trump's designation decisions. And they'll say, well, Trump never filled out the form, or Trump never talked to Deb about any of this, and never gave an order to specifically move these things out of one location into another location. And Trump is just going to respond and say, I had no obligation to do any of that. They're my records. Sorry, you guys already decided this in Clinton's case. They also say the Presidential Records Act recovery mechanism, okay, even if there was some sort of a problem or confusion with the Presidential Records Act and the president's sole discretion to declare the documents as personal, even if there was a problem, it's not a criminal problem. In February 2022, a NARA official informed the FBI that NARA had never made a referral to the DOJ. Isn't that interesting? Never. Yeah, and that's after Trump was out of office, obviously. So NARA says, well, hey, FBI, it's kind of our first time. Wondering if you can help us out with this. Like, sure, what can we help you with? Well, we want to go after Trump. FBI is excited as can be, like popping out of a jack-in-the-box. We can help you with that, right? They're ready to go. The history is entirely consistent with the absence of both criminal investigative tools and criminal penalties in the PRA, because they've never done it except for Trump. Now here, there are other cases being cited, but they say, look, given the PRA's limitations, as acknowledged by NARA's historical practices, even the NARA OIG lacked reasonable grounds to believe that there had been a violation of federal criminal law when it transmitted this sham referral to the DOJ on February 9th. So even NARA's Office of Inspector General said, well, we think we lack reasonable grounds to believe there was a crime. But NARA said, we don't care. We just need a pretext to go prosecute Trump. NARA's purported referral to DOJ prosecutors was therefore improper, and it was not foreseeable to President Trump given NARA's historical practices, right? This is a notice problem. You're saying that Trump was following the same code of conduct, the same course and manner of the law as everybody else, and now it's a crime? That is like creating a new law, right? And so Trump didn't have proper notice about what conduct was permissible and not. And so now it's like you just passed a law to prosecute him specifically, and that is not allowed under our Constitution. Now, because the referral was improper, there was no basis for the FBI to predicate an entire investigation on it. And so consequently, Trump's team continues. They say the obstruction and the false statement allegations that come from count 32 and 42, the first 32 counts are the documents. Okay, but Trump is allowed to have the documents because they're personal records. So therefore, if he's allowed to have them, the obstruction and the conspiracy charges, those also got to go. Saying, as the DOJ said in the prior Judicial Watch case, they said that the alleged violator here is a former president of the United States. They were talking about Clinton. We love him. When enacting the PRA, Congress was keenly aware of the stark separation of powers questions implicated by legislation regulating the conduct of the president's daily operations. That's the DOJ's own quote, right? Now they're saying Trump has to check every book out with a library slip and turn it back in by Thursday, whatever. To the extent NARA seeks to recover what are now properly designated presidential records from any third party, including a former president, the PRA provides the exclusive means for doing so, if that even is a thing, even if these are presidential records and not personal. The only way you get them back is with civil remedies rather than a criminal prosecution. But they had to create a new criminal charge against Trump. The FBI guidelines also require that to properly predicate a preliminary or full investigations, an activity constituting a federal crime, you got to have information related to the activity there, and that's from the DOJ guidelines. So they say, continuing, specifically, when there is a problem, if the Presidential Records Act needs to go get some records, the PRA authorizes NARA to invoke the same enforcement mechanisms that's in another part of the code called the Federal Records Act. And the Federal Records Act, it establishes the only one remedy for the improper removal of a record from the agency. One way to get them back. And Congress opted in favor of a system of administrative standards and enforcement. Now, the process begins with a request to the Attorney General to institute an action for the recovery of the missing records. Now, in response to a NARA request, the Attorney General then may pursue recovery via replevin, which is the returning of property, right? Here, replevin action related to a map annotated by Kennedy during a Cuban Missile Crisis. They went and got that back. Now, tellingly, it is precisely what the DOJ did in response to the portion of the February 9th sham referral from the NARA OIG that did not relate to President Trump. Okay, so there were other documents. In an effort to recover those other records, the DOJ initiated a replevin action rather than a criminal investigation, grand juries and search warrants. They saved all that for Trump. So there are other incidents where they go get him back in a different manner, and they just raided Trump. Now, in Armstrong 2, the D.C. Circuit went even further, and they suggested that neither the archivist nor an agency head can initiate any action through the Attorney General to effect recovery of the presidential records. You can't get them. This is the D.C. Circuit saying this. Compare the U.S. Code and other codes. They say an archivist, well, I'll skip that footnote. But anyways, more footnotes there with more details. Now, Trump's defense continues saying, according to a brief filed by the DOJ and the National Archives in Judicial Watch, so again, years ago with Clinton, Judicial Watch is trying to pierce this to get access. NARA and the DOJ says, get out of here. They both said this, responding. They said, this administrative enforcement scheme is exclusive, and courts may not order the recovery or the retrieval of records that may have been removed or destroyed. Which is weird because they got a search warrant for Trump. So why did the judge in Florida author a search warrant if even the DOJ and NARA admit that courts may not order the recovery or the retrieval of records? They admitted that in a prior filing, in a brief. Now, the PRA does not require NARA to physically seize presidential records, but instead it relies upon a much more limited and a sensible administrative enforcement scheme. The Judicial Watch Court, when they were reviewing that case with Clinton, they observed that. They said, quote, because the Clinton recordings are not physically in the government's possession, NARA would be required to go seize them directly from Clinton, which I mean, they did that with Trump. And NARA considered such a seizure to be an extraordinary request that is unfounded and contrary to the express terms. The DOJ made similar assertions when they were in oral arguments. The judge was asking the DOJ questions when they were trying to protect Clinton. The judge said, hey, government lawyer, let's say a president kind of maliciously overclassifies, as presidential records to avoid a FOIA. What is the remedy? Overclassifies. Like, what if they did, put them one way or another so they can't get them? And they said, well, Your Honor, if the president classifies it, the first one and the primary remedy is that it always lies with the archivist and the attorney general who have the authority. If they believe the president has misclassified something, that they can invoke the discretionary enforcement mechanism and they can pursue the recovery of those records civilly. Now, the DOJ characterized recourse to the PRA's discretionary enforcement mechanism as a very serious step for them to take and noted, if Congress believes that the president is wildly misclassifying information, it can pass a law to change the structure and they can seize those records. Now, Congress has not done so, leaving in place this civil recovery mechanism as NARA's exclusive enforcement option under the PRA. And again, I would challenge a lot of that. Like, again, these are the executive's documents at root. And Congress, in my opinion, if they wanted to take control over all of that, they'd have to amend the Constitution on certain categories here. So anyways, Congress, they say, they know that explicit language is required to rebut the exclusivity default. For example, there's a pending bill that would add a civil enforcement option, and so on. Now, in conclusion, Trump's defense wraps this up, and I like this argument. They say, for the foregoing reasons, President Trump respectfully submits that the court should dismiss this entire indictment, the entire classified documents case, gotta go, based on the Presidential Records Act. Another great filing, part of a massive motion to dismiss drop from the Trump team, and we're going to be covering all of these motion to dismiss filings that have come out, and this is one of many. But this is a big one, okay? And the double standard here abounds. You can see it clear as day. Bill Clinton, as the president, has the power to do those things. Now, you might think that that was inappropriate of him to do what he did and classify a bunch of stuff that he kept in his sock drawer. Maybe I would agree with you, but he's the president, and that is the president's right. If you say, sorry, anybody can just declare that your discretion usurps the presidential discretion, that makes you the president, and it takes away the power of that position. And that is how you invert the whole constitutional order when the president is clearly the executive of the executive branch. It doesn't work if you subordinate him to someone else who doesn't have the lawful power. What happens? We're living through it. We're watching what happens when they invert all of this. They start prosecuting their political enemies. They pat themselves on the back like they did a good job. But the case precedent shows us clear distinction, even in DC's own circuit, between presidential and personal. And the idea that Trump took the documents or he didn't fill out a form is not dispositive, right? Clinton didn't turn his materials to the archives. By default, they automatically then become personal records, not subject to review. Trump did the exact same thing using the same precedent, and they created and concocted a crime out of it in a way that they've never done historically. This calls it out, and we're not in Judge Chutkan's courtroom. We're now in Judge Cannon's courtroom, and when this comes up for oral arguments, we can't wait to hear what Jack Smith and his deranged thugs, including Jay Bratt, say and how they try to defend this. And so, my friends, we're going to be here continuing to cover all of this, and so I hope you join us as we do. We had a little bit of an update from CNN. They were sharing with us some of Trump's plan to use these two cases
we have new CNN reporting
against one another to gain an advantage in the trial calendars moving forward. And this is an excerpt from CNN explaining how these trials are going to be unfolding here very soon.
John, Donald Trump doesn't want to go to trial. That's not new, but
I kind of think that he does, but when it's appropriate. He doesn't want to race to trial when they're trying to squeeze through 12 million, 13 million pages of discovery down his gullet without even the opportunity to read it. So we'd like a fair trial, not a rigged trial that was conducted and colluded to be executed before the election began.
the strategy that he is going to be employing through his lawyers does appear to be something we're going to see play out in the coming days. So right now, Trump is set to go to trial in New York in his hush money case at the end of March. That'll block out the calendar for him to be in trial as a criminal defendant late March to about mid-May. Then the calendar's open after that, and there are two federal cases that are vying for
Florida,
the possible
J6.
Places on that calendar. There's the possibility that that January 6th case in Washington, D.C. could get back into the hands of the trial court and could be headed to trial. And then, of course, his Florida documents case. But just this week, his lawyers are headed into a really crucial hearing in that Florida documents case before Judge Eileen Cannon. They have a trial set for the end of May. It's very likely that that's going to get moved. So what they want to do is move it just a little bit, just a month or two into July, and then the possibility could arise, because that case is so complicated with classified documents, that it might have to move again. So it would essentially elbow out any other trial if it just has a place in the calendar and gets moved along through the summer, so Trump would achieve his ultimate goal of not going to trial before the election.
Which means that Jack Smith would fail his goal. It's Jack's goal. It's not Trump's goal. Okay, he didn't prosecute himself. Weird people at CNN. That's you guys. And so Trump now just wants some due process, just wants equal protection under the law, wants to be able to flesh out each one of these issues, because a defendant deserves a right to a fair trial, not one that is being conducted by an illegally non-appointed, deranged thug like Jack Smith, who's not even a U.S. attorney, in order to take out their political opponents in the middle of an election. And so, my friends, we're here, we're covering this one. We've got a few more motions to dismiss coming down the pike. And so thanks for subscribing and joining us as we continue our coverage here, not only of the classified documents case, but all of the rest of the Trump prosecutions and ballot removal litigation and SCOTUS appeals and the rest of them. And so we'll be here, my friends. Thanks for joining us as we do. Don't forget to check out some of our links down in the description below. We have an amazing community where we do streams in the morning and streams on Saturday at watchingthewatchers.locals.com. We got great events coming up this month and next at watcherlodge.com. Free events, including political Zen wellness and some other things. And so go check those out, my friends. And don't forget to subscribe, and we'll see you right back here on the next one. All right, my friends, now it's Fani time. All right, we're getting ready for it. We got some good stuff to get to. Oh, all right. You know who it is, my friends. This is the gift that keeps on giving. And so without any further ado, let's just get right to it. Fani Willis rages over the cell phone records that have been proffered to the court by Trump's defense. We reviewed those in depth. We learned that even though Nathan Wade said that he was only over at Fani's condo, less than 10 times, turns out it was about 35 times. They were texting each other all hours of the night. There were some Fani booty calls going on. Nathan Wade got the call at 11:30. Fani's like, I need to be indicted right now. He's like, I'm on my way, baby. He gets in the car and they track the whole thing. His cell was pinging off the towers on the way over to Fani's condo. And we have some concerns that they lied to us, because they said that their relationship didn't start until 2022. They put that in an affidavit to the court. They may have lied about that, because many of these phone calls and text messages, thousands of them, were taking place in 2021 before this all started, according to them. And so now we're talking about perjury. And now we're talking about losing your law license and maybe going to jail. And so Fani's very upset about this. She responded, and then Trump responded. And so we're going to see how Trump just obliterates her response. But Fani was very, very upset. All caps, bold, underlined. I think the only thing she forgot was the italics, but that makes it look weird. So here is Fani's response. Very unhappy in Fulton County, Georgia. Fani comes out and responds to Trump's submission of cell records that show these two little lovebirds were colluding with one another in the bedroom a full year before they told us it started. Fani responds. She says, all right, Judge McAfee. Here is Fani's objection. They say, here comes now Big Fani Willis, the biggest Fani in Fulton County, and we move this court, McAfee, to exclude Donald Trump's proposed Exhibit 38. That's the cell records, which has been improperly submitted to this court in violation of the law. They say supplemental Exhibit 38, the reason why this has to go, it contains both telephone records that have not been admitted into evidence and an affidavit and other documents containing this expert's unqualified opinion evidence. And for the reasons set forth, this court must exclude all of this material, or at a minimum, consider our government rebuttal evidence. They tell us. Now, a lot of this is going to be technical. So in any criminal case, you have expert witnesses, and one of the things that you want to do is make sure that they're actually an expert. And there are standards about this that the courts have articulated for us, and it comes from a case called Daubert, which we'll hear more about. But they're going to try to get that testimony, that affidavit that shows all the cell phone records with the slideshow and the heat map and all the stuff that we described, but we didn't actually see because it was filed to the court exclusively. They say that that is just unreliable. It's not from a real expert. They say Trump and his proposed exhibit was improperly submitted in direct violation of this court's own rules. Now they say while Trump and his exhibit, while it cleverly avoids the use of the term expert, it is clear that Trump's submission is an attempt to have this court improperly receive unqualified expert testimony. And what they're doing is they're citing the court's own rules. They're saying, Your Honor, you said in your standing case management order for criminal cases, you said you got to provide written notice to the opposing party. You got to disclose a summary of the expert testimony, and you got to do it 7 days before any evidentiary hearing that requires that person to come in. Right? And so this is what the judge signed, for the prosecution, for the criminal case that is brought by Fani against 19 co-defendants, now 15. Remaining 4 have taken plea deals. So the court's own order goes to that to those provisions. And they say, sorry, judge, this is you already, said the rules, like you can't change the rules after the game starts. And so you already said we needed 7 days notice. You already said we needed written notice. You already said we needed a meaningful summary, and we never got any of those things. They say here, Trump's proposed exhibit, it violates your order. Trump provided no written notice to us. Trump provided no summary of their testimony. I mean, he kind of did. It's in their affidavit. Trump provided no information related to the qualifications of him. Well, he did, right? It's in there, but they're saying, well, he should have given us to us before he filed all this. And no notice was provided at least 7 days before the evidentiary hearing, right? We should have gotten it earlier. Now, you could turn around and say, yeah, I mean, you got plenty of notice. It's in the filing. We all read it. Most of America has read it at this point. We know what you two were doing. And, these are all technicalities. And I would say, well, this whole thing is a deviation from the standing case management order, which is for the 19 co-defendants, now 15. But they say, look, at the conclusion of a portion of the hearing that was held talking about disqualification, they say Trump stated the following. They said, okay, McAfee, we're in the process, if the court will allow us, to get certain phone records. And we'd like to keep the record open for the introduction, and we'd have them in draft informally and blah, blah, blah. But they say, we'd like to reopen and introduce records and someone to explain what they mean. Right? This is Trump's team back during the hearing. And counsel for Roman, this is Ashley Merchant. This was Steve Sadell. Merchant said, as soon as we get a hearing date and the state's response, when the state responded on the 9th and admitted to their relationship but put parameters on the timing, I sent subpoenas out in response to that. The problem, though, says Ashley, Delta, AT&T, they aren't fast. And so I wanted to remind the court, waiting for those records to be submitted in camera behind the judge, behind the bench in the judge's chambers. And actually, AT&T emailed me these phone records yesterday morning on the way to the court. So they're saying, okay, see, even the defense lawyers, this is Fani's team writing, even the defense attorneys were saying, like, at the hearing, they were saying, we have to get these records. And they say representations made by the defense team, they make very clear to the court that they issued subpoenas for telephone records that are at issue on or about February 9th, that they had subpoenaed their records at least as early as February 15th, and defense counsel, they always intended to attempt to introduce both the records and an expert witness to explain what they mean. So they're saying they were plotting on us. They were colluding. They know what they were going to do. We're like, yeah, they did. That's why Steve Sadow asked Nathan Wade that question, because he knew he had evidence that he was going to hit him upside the head with. Now, in spite of this, they say Trump made no effort to comply with your own orders, Judge. And Trump provided no written notice to us in advance of this hearing. And so if we don't have notice, you got to exclude it. And provided no summary and provided no information related to his qualifications. And your orders, you already said this, Judge, was specifically intended to prevent this ambush type of legalese with purported expert evidence without allowing us a meaningful opportunity to review any of this and to review the purported report and to obtain our own expert in rebuttal. And so we just got totally blindsided by it. We had no idea. So the court cannot now, says Fani's team, cannot now allow Trump to bypass this protective procedure when, in other cases, it has excluded expert evidence for a party's failure to follow the order. Now, all parties coming before this court must be treated equally, which is LOL, isn't it? Treated equally. Fani, give me a break. Should they all get millions of dollars from the taxpayers too and sleep with Fani? No thanks. Indeed, treating like cases alike promotes a system of equal treatment under the law rather than one built on arbitrary discretion, which is literally what this entire case is. And he is citing a case that references Alexander Hamilton, and I'm not happy about that. Keep his name out your mouth. Here is the guy who's writing this. This guy's name is Adam Abate, okay? The same guy who is screaming about sanctions. Yeah, Adam Abate, okay? The same guy who wanted sanctions against Ashley Merchant, now quoting Alexander Hamilton. Give me a break. All right, so he continues in his rant. This is Fani, okay? So I'm going to show you where Fani comes in. Defendant Trump's supplemental, they also say, was in violation of other rules. They say, first of all, Georgia's rules of evidence say expert testimony has to follow the rules. And we know that in different cases, there was this Daubert case, which was a Supreme Court case from 1993, which tells you how to qualify experts. But they say Trump now seeks to submit another exhibit, which contains this affidavit from this dude called Charles Middlestat, that consists of opinions that are based on science and technical and specialized knowledge under the rules. And so if it falls within that, if it's scientific, if it's technical, or if it's specialized, it meets the Daubert standard. And under Georgia law, he's got to be qualified. And they say no applicable exceptions exist under here. He is an expert. And so if he is going to be an expert and proffer this affidavit, then you must consider these things. One, expert scientific, technical, or other knowledge. The testimony, whether it's based on sufficient facts or data. And this dude, does this all the time. He explained that in his affidavit. So I'd say that's good. Testimonies based on sufficient facts or data. He got a full year of phone records from Nathan Wade. I'd say that's good. If we even needed him as an expert, we're not there yet, but if we did, the testimony is the product of reliable principles and methods. Yeah, Fani Willis and her office used this stuff in their own prosecutions. And the expert, this guy Middlestat, has reliably applied the principles and methods to the facts of the case. I'd say he hits that one too. But they say the party advancing this has to make sure he's admissible, and we haven't done that yet, right? So even if the judge wants to accept this, he's got to go through this process. 4 steps. You got to verify he's the thing. You haven't done that, Judge. Therefore, here, none of the required findings have been made by the court, and no timely or competent evidence that complies with your prior order, you already said it, no takebacks, exist in the record to establish that even one of these factors is met. And Trump has provided no competent evidence whatsoever that would establish that Middlestat is an expert in anything. Fani continues. Now, moreover, the telephone records at issue themselves, so this is all disqualification stuff for the expert, saying this guy's not even trustworthy. Get him out of here. But even if you look at the telephone records themselves, which form the basis of his entire expert testimony, they are not properly in evidence anyways. No one has authenticated this. And if you're trying to introduce this as a business record, it says you shall make both records and the declaration available to the adverse party. And so once again, we didn't get enough information. And contemporaneously providing the certificate and the telephone records after the close of evidence, they say the hearing's already done, is not sufficient to advance notice. Now, the court should not excuse Donald Trump and his failure to comply with the law. It's clear that Trump subpoenaed these records as early as February 9th, and they keep bringing that up, to say that he could have told the other side about this and had both the records and the declaration in his possession by the 15th. Rather than telling us about any of this, he never provided notice to us. And now he's attempting to ambush the state with these unauthenticated records only 5 days in advance of the scheduled closing arguments to provide the state an opportunity to rebut this evidence. And again, they are a prosecutor's office. They should have cell experts on call readily. They're probably prosecuting people with similar evidence. So they're like, we're scrambled here. So the court should not now reopen the evidence, right? A lot of this is technical. Disregard its own standing order and allow Trump the opportunity to qualify Middlestat as an expert witness when it's already declined to do so. All parties coming before this court must be treated equally. Now, if the court determines that Trump's inadmissible can be considered, then you must also consider our rebuttal evidence. And I think this is where Fani's coming into play. Yeah, you see it there? She's coming up. Says here, notwithstanding the inadmissibility of Trump's exhibit, pursuant to your own evidentiary ruling, phone records are inadmissible. When the state attempted to impeach Terrence Bradley by concerning circumstances about his departure, the court said you can't introduce extrinsic evidence to impeach him, right? And remember this testimony. Terrence Bradley was up there. He was vouching for Nathan Wade. You know, we're like, wow, this guy's totally lying on the stand. Okay. Anna Cross comes out and is like, didn't you assault your employee and a client? He's like, what? Absolutely got shanked in the back multiple times by Nathan and Anna. And Fani was back there too. And so they tried to bring in that relationship, the assault relationship between Terrence and someone else, in as evidence in this case. And that's not what we're talking about here. We're talking about Fani and Nathan. So the judge said, well, under Rule 608, I don't see how this is relevant, and kept all of that out. But now the government is saying, well, if we can't bring in outside material to impeach our witnesses, you can't bring outside material in to impeach your witnesses. But this is very different, right? Because the evidence that is being brought to impeach Nathan Wade is the cell phone records. And that goes to the core of his credibility, which does relate to the issue, which is the Fani-Wade relationship. So this whole point, I think, misses the mark big time. They say here, Trump attempts to do the same thing. He seeks to introduce extrinsic evidence that's contrary to Nathan Wade's testimony for the purpose of impeachment, because it's related to the relationship. Now, if the court did not allow the state to impeach Terrence Bradley, who's not a subject to this relationship, it cannot allow Trump to do the same thing. All parties coming before this court must be treated equally. Is that the second time they said that? Oh, they're like broken records. Yeah, again, thanks for that. Thanks for repeating yourself. Now, this is where I'm pretty sure Fani was in the room when they were writing this filing. Look at this. Look at this. It's about to get heavy in here. So this prosecutor continues, but even if, Judge, in spite of all these evidentiary deficiencies, if this court determines that it can still consider Trump's exhibit, well, the phone records simply don't prove anything relevant anyways. The records do nothing more than demonstrate that Special Prosecutor Nathan Wade and his telephone was located somewhere within a densely populated, multiple-mile radius where various residences, restaurants, bars, nightclubs, and other businesses are located. Then it's about to get spicy. You can see Fani is here. She says, I think this next sentence should be in bold. He says, I think you're right. I'll put it in bold. And then she says, that's not good enough. Underline it. He says, Fani, I'm not sure. That's too much. I think the judge might get mad at us. Underline it. Ah! He's all right. Control you, control you. He underlines it. Fani starts screaming. The records do not prove in any way that the content of the communications between Special Prosecutor Wade and DA Willis are there. They do not prove that Wade was ever at any particular location or address. They do not prove that Wade and Willis were ever in the same place during any of the times listed in the exhibit. And in fact, on multiple relevant dates and times, evidence clearly demonstrates that Willis was elsewhere, including at the Fulton County District Attorney's Office. And then they go into psycho caps lock mode. Fani's like, caps lock it now. He's like, all right, I'll do it. Caps lock. And visiting the 3 crime scenes where a mass murder motivated by race and gender bias had taken place. And everybody's just like, oh, period. Oh, he's crying. The guy who's typing, oh, why'd you do, man? And, you know, there are a bunch of people there. She wanted to increase the font, too. She was going to italicize it, but it probably looked weird. She was going to increase the font, like, probably to, 14, maybe 16. And everybody had to pull her back, okay? People were, like, pulling Fani off the keyboard. That poor guy. So hopefully he's recovered. So you can see, my friends, I'm only, like, half joking about this, like, she's actually yelling in a court filing. I don't think I've ever seen this. All right. Screaming about race and gender bias. Screaming, right, in caps lock. Ah! Like, you're writing in all caps, Fani. You're screaming at the judge. And she's screaming, apparently, because she was investigating a murder focused on race and gender. And now Trump is trying to murder her based on race and gender. Now the DA is getting murdered here, Judge. I'm getting murdered too. And this is wild. Like, I understand, bolding a word or two, but you're not going to see this much more here, my friends. We read a lot of court documents here. A lot. Have you ever seen anyone screaming at the judge? Screaming. And visiting 3 crime scenes. Like, that's what's happening. Remember the scene from her in court where she's grabbing the documents? It's a lie. That's literally what's happening here. She just wrote it. And so it's just very dramatic. So anyways, they say the state submits that Trump's proposed exhibit was not filed in good faith, but instead it's nothing more than an attempt to garner salacious headlines in the media. The New York Post article and others are patently false, and others are misleading as well. And roughly simultaneous with the filing, counsel for Trump, Sadow, immediately provided unredacted cell phone records, which he admits was a mistake, that contained personally identifying information to the media. And he responded in an email. He said, sorry, I accidentally, gave it out. Trump's proposed exhibit, it includes an attempt to introduce an affidavit, even though Trump insisted the state was disallowed from doing so and compelled Wade to testify. So you made our guy come in and testify, but not their guy come in and testify. We couldn't submit an affidavit, so they can't submit an affidavit. And saying Trump's proposed exhibit also fails to comply with the court standing order and evidentiary rules. And moreover, the state questions, here we go, whether Trump legally obtained the cell site information in the first place. Like, these are the prosecutors who are now threatening them with crimes almost. How did you get that? Which is generally only obtainable after a finding of probable cause and an issuance of a search warrant. And what we've learned since then is that this is common procedure in Georgia. Defense attorneys get cell phone records all the time. It's just basically a public records request. If you're a lawyer and you're on a case, you can request it. I learned that. And you know how long I've been practicing law in Georgia? 0 years. You know how long this guy has been? I don't know. But he's a prosecutor. And so when we talk here about how incompetent this whole office is, you're watching it on display. We might charge them with the crime because they got a search warrant, got a subpoena. They're allowed to do that, weirdos. For all these reasons, it's clear that Trump's exhibit is inadmissible and it was not filed in good faith, and so it should not be considered by the court. Yeah, that's a one word right there. And for the reasons set forth Below, the court must exclude the inadmissible statement and exhibit from Trump. Now, we're not done on this one yet. This is just even more ridiculous. So I want to share with you, remember when they said she was all over the place at these various locations? She was working. She was on other locations at relevant dates and times. She was working, all right, at the DA's office. And so to show us how hard she works, they included some of that material for us to take a look at. Here is the case management order, which is for, the defendants, for the co-defendants, not for Fani, but all right. She says it should apply to me too. She thinks she's on trial. She's not. I mean, she kind of is for disqualification, but none of that necessarily applies to her. Point is, here is the phone records, which were also sent in. So this person certified the phone records and authenticated them. Kiviandria Lang did all of that. Now look at what Fani has given to us. Remember in the affidavit that was submitted by Middlestat, there were 2 different dates and times in there that he investigated. One was, I believe, in September. The other one was in November. One was before the appointment, and both of them were before they alleged their relationship started. So 2 dates were investigated pursuant to the affidavit, and Fani just returned a bunch of redacted emails, okay? We talked on Friday about how flipped they were in their office, how it looked like probably, the place was on fire. Everybody was running around. Dogs and cats flying all over the place. It was madness there in Fulton County. And Fani then just printed out a bunch of emails. And she's like, here, just slap that to the back of this stuff. And here's what she sent in. So apparently, here's one filing in Exhibit C. I don't even know what this is for. But here's the subject, cases presented, okay? So she says, I was working. I did work. On August 3rd, I was there. And I got an email about cases presented. I sent an email. I sent one to someone, cases presented on August 3rd. Great. Then here's another one. This email is also from Fani on Tuesday. Another correspondence. Big deal. Here's another one, August 23rd. They send in some emails. Look, she's sending emails back and forth. Understood. Like totally irrelevant. Greetings all. Responding to this. Now, some of this might be filed under seal, so we don't know what it is, but she's probably talking about that murder. I was here and I was investigating this, and I'm Fani Willis and I'm doing all this. Okay. Thanks, Fani, for showing us that you actually did some work. Now then, to really confirm that for us, she also gave us her calendar. And I know many of you work your butts off out there. I certainly do here. And when we start our days, we usually have somewhere to be, kind of early in the morning, some obligation, especially on a Monday. Mondays are pretty busy. But this is Fani's calendar from April 12th, 2021. This is before Nathan Wade's appointment. This is before Fani said that they were in a relationship in 2022. And so let's take a look at her grueling schedule, shall we? Here's a day in the life of Fani Willis. It's a Monday. You know how Fani gets. She needs her mornings to herself. So don't bother her. Fani's going to stroll into the office. What time is she going to get there? 11:30. Please don't bother me in the morning. And courts have 8:30 dockets, 10:30 dockets, a lot of activity in there in the morning. But Fani can't be bothered. No meetings before 11:30, all right? Then when she finally gets into the office, she has her first meeting at 11:30, and you know what it is? It's lunch with her boyfriend. Yeah, Nathan Wade. It's a meeting with the anti-corruption team. Okay, and it's with Nate. That's Nathan. That's Nathan's team. And it's a meeting with Fani and Nathan. It's a 2-hour lunch in the conference room. All right. With her anti-corruption team, AKA her boyfriend. 2 of the most corrupt people in Fulton County, they have an anti-corruption meeting, right? And they call it an anti-corruption meeting. The other name they could have called it was the definitely not sleeping with each other meeting, Oh no, we're going to meet about why you shouldn't sleep with your employees and your staff. Put that on the calendar. So the corrupt meeting, the most corrupt officials have an anti-corruption meeting for 2 hours. Okay, so they have lunch from 11:30 to 1:30. Fani is supposed to be paying attention to this board meeting, but it's a Zoom meeting. So she just calls in, she puts it on, she turns her camera off because she's busy with her boyfriend for these full 2 hours. And, camera off, like whatever board meeting, she sits there talking to her boyfriend. Then there's some child abuse prevention thing, half hour. She probably shows up. Thank you. They give her an award, whatever. Yeah. Hey, great. And then after that grueling day where she turns off her camera for a board meeting, spends 2 hours with her boyfriend, then that afternoon, guess what's next? Oh, 100-day celebration for Fani Willis. It's like a joke. 100-day celebration for 2 hours from 2 to 4 o'clock. And a bunch of people got an invite to this. It was in the courtyard out the Pryor Street courtyard area, beautiful area, near the Assembly Hall. Oh, isn't that beautiful? And it's celebrating 100 days of accomplishments. Wow. What a historic effort this is. And then apparently there was some other meeting in a conference room. I don't know if that was Nathan again, indicting each other. And she blocked something else here for Fani Willis, celebrating Fani. Fani has on her calendar to celebrate Fani. She is the biggest Fani in Fulton County, obviously. So they gave us this date, right? She does nothing. And, maybe she was coming back from a cruise here, which is why she was so tired. She needed to take the morning off. But this is April. This isn't any of the 2 dates that we have any concern about. So she just showed us some random day of her schedule, which is like pathetic. Okay. Most people, this schedule is like a joke. All right. It's like a joke. And I used to practice law very, very aggressively. I would be in 4 courts in one day. 8:30 docket, 1 court, 10:30 docket, a 1:30 docket, and a 3:30 docket in multiple locations. Now, you're not going to do that if you're the county attorney, but this is like, I don't know what this is. That's one example. They give us another one, okay? This one is on April 20th. And again, not one of the 2 dates that was in the affidavit in the first place. So then they have another meeting with whoever that is. I don't know who that is. Is that Nathan Wade? I don't know who that is. So that's a 3-hour meeting. Don't know. Meeting with somebody. Probably not Nathan Wade. Probably someone else. Here's another meeting with someone else. There's a beginner session for some Odyssey training, whatever that is. And then there's more training, okay, which I'm sure Fani's not doing anything of that. So she's sitting here rapping about something with somebody and then sitting in training from 12 to 5. That's your county attorney, grueling schedule. Here's May 10th. Oh, she's working on the spa killings, whatever that means, right? So she's sitting around in the mornings, letting other people do a bunch of work. Then she talks to the Zoom meeting victims from 5 to 6 o'clock, right? This day is a little bit more substantive than the other ones, but there's some legal work probably happening here. She's probably having to look at some case files here and then talk to some victims there. Okay. Yeah, that's some heavy work. I get it. But this is the rest of Fani. Okay. And the rest of her filing is just, I do work, and see, she's saying here, can I see you before you push this one to the printer? This is November 17th. Okay. 4:44 PM. Now we're in the ballpark of the dates we're looking at. And we notice this, look at the size of her signature. Okay, that's a 32-point font at least, I would say. At least 32-point font. And I have to point out the obvious, that when we call her the biggest Fani in Georgia, she confirms it at every opportunity, all right? You know that she's Fani Willis because of her email signatures. It punches you in the face when you get an inbox. I am Fani Willis, baby, yeah! Signing her signatures on every one of them. All right, here it is again. Here's another one. Fani Willis. Here, I do actually work, I am working. I told someone to order these books today. Fani Willis. Don't you forget it. All right. Everybody that she talks to, make sure they remember who she is. So, all right. The rest of this is just emails. It's like, I do work. I'm not only indicting my boyfriend. And the rest of this is just articles from all the people who say that she's corrupt as hell. So that is the response. Now, Steve Sadow did confirm that some records actually got out to his error. Steve Sadow says, I inadvertently sent the unredacted cell phone records to Bill Rankin this morning. When I realized the error, I immediately contacted him, told him, do not disclose that to anyone else and do not publish the cell phone numbers or other protected information. Mr. Rankin indicated that he understood and he would not publish the cell phone numbers or the address. It was my mistake alone. So mistakes happen, you know, not something that is intentional, obviously. And my understanding is that those numbers have gotten a bunch of phone calls to them. And I want to always say that, you know, any phone calls to any public officials get looked at with extra scrutiny. Any texts, any phone calls, any messages, they will arrest people and put them in prison for that. So, you know, be extra cautious with any of that information if you've come across it, and they don't play around with that. So that is Fani's response. And you can see it's kind of a ranting screed. She's literally screaming at the court in all caps, underlined and bolded. I don't think she increased the font yet because she has somebody stopped her for sure, but she might next time. Now, she gets obliterated in the next filing by Trump's response. Donald Trump's defense team responds to Fani Willis, who is trying to get the phone records deleted from the history books because they're so damning to her case. They do not want Exhibit 38 to be admitted as evidence. And Steve Seidel, the person and the team that originally got this data in the first place, are responding. They say, this is President Trump's reply to Fani Willis's attempt to exclude this evidence. They say, all right, Judge McAfee, your affiant Middlestat, the person who created that affidavit that detailed all the records, is not being offered as an expert witness. So neither the court's standing discovery order nor the Daubert standards under the Supreme Court apply. Sorry, Fani and Abate. They say the state protests that the defense, that's us, Trump, is somehow not entitled to present expert testimony regarding the cell site location information, as they allege that the defense failed the court's standing discovery order. That order mandates prior notice to the opposing party of a party's intention to introduce expert testimony because they claim that the defense has not pre-cleared the evidence through the process of a Daubert hearing. However, Trump's defense says, well, it's a nice theory, but neither of those preconditions apply here because the cell phone information that the defense intends to introduce through the testimony of Middlestat is not being offered through expert testimony. And Middlestat will not be offering any opinion testimony at all. He instead will be summarizing the data that was produced by AT&T in response to a lawfully issued subpoena, as well as factual information that he acquired regarding cell site locations. And there's a footnote here that says, you know, the state is being pretty ridiculous. They put on the final page of their useless motion that Trump obtained the cell phone maybe illegally, the cell phone records, calling it a last-ditch claim. They say that is patently frivolous. These prosecutors should know better. The records were obtained by a valid subpoena issued to AT&T. As the state hopefully knows, hopefully they don't know, defense counsel cannot apply for a search warrant, and a subpoena that they did apply for does not require the probable cause standard to be met in order to be issued. So again, like, these prosecutors are not that competent, and they're correcting them right there. No, yeah, we are not allowed to get a search warrant, you know, because we're not prosecutors like you. That's you. But we can get subpoenas, and in Georgia, it's pretty easy for them. There's an exception that allows them to go do this, so they do it. So obvious. Now, Trump's defense continues. They say, first, let's be clear about what's happening here. Middlestat is not an expert, and so he's not going to fall within all those requirements that you articulated before, Abate. They say, first, the 11th Circuit has held that precisely the type of evidence that Middlestat will offer does not require the testimony of an expert. You can go to the 11th Circuit case from 2014 and find it. In Ransford, the government presented a witness from the cell phone service provider who explained how cell towers work and how evidence preserved in the company's computers can show what tower a cell phone was pinging at a certain time. And a police detective also testified how call phones ping off towers. And in that case, the Ransford court explained why the company's witness was permitted to offer testimony. And that testimony was neither expert testimony nor was it opinion testimony about the cell towers and the locations of the phone. Here's what the court said. They said in this case, the prior case, the Dikovitsky, who was the witness, this cell phone witness guy, he explained how cell phone tower records pings from each cell phone number and how he can map the cell phone tower locations for each phone call in numerous exhibits. Now, Hannah, the other side, does not point to any statements of opinion by the expert or the non-expert, and we do not find any in the record. So what was his opinion? If he just comes out and describes how it works, is that an opinion? No. Hannah didn't. There was no opinion. Hannah does not contend that this testimony was beyond the witness's personal knowledge or that the cell witness should have been treated as an expert. And so we rely on another case where we held that a financial expert's testimony that matched billing records to payroll were factual statements. They were not statements of opinion. So if you have somebody come in and say, well, this is how all this works, what is your conclusion? Well, based on all of this, it's my conclusion that, which like in the George Floyd case, for example, okay, those were experts who came in and said, I think it was the knee to the neck. Other people said no. They had a conclusion. But if you just brought in somebody to come in and talk about how lungs work and not come to a conclusion, that's a different type of witness. So the testimony did not require expertise because it was a summary of financial records that the witness already reviewed. And it was an explanation of how the summary was calculated. And so, moreover, there was no suggestion that it was inaccurate or prejudicial since there was no opinions. And so the testimony was properly admitted under the rules. Trump's team continues. They say the holding in the Ransford case that is relevant here, it dictates the results in this case. Questions about the interpretation of Georgia evidence code, they rely on the 11th Circuit precedents from Georgia appellate courts. Go up to the 11th Circuit unless Georgia says differently. There is no contrary authority from any Georgia appellate court that says we can't use this witness how we're intending to use them. And secondly, there is clear authority that cell tower evidence, like Nathan's, linking a particular phone with a particular cell tower at a particular time, that can be established through the cell phone records without any witness testifying. The 11th Circuit in Sanchez said that they approved the use of business records exceptions, so to admit cell phone records and tower records that documented the tower nearest to the cell phone when the phone was by that tower, as well as the number that was called. All of that was allowed. The government, this is why this is so fun, is because normally it's the defense saying, you can't admit that. That's my right to privacy. That's an invasion. And the government said, no, that's fine. Government can do whatever they want. It's just prosecutors. You're a criminal anyways, whatever. So the government in that case was permitted to later call a detective to testify only as a summary witness regarding what the record showed. Now, Georgia courts, both before and after the new code was enacted in 2013, they've allowed this. They've approved the business record exception to admit evidence to show the location of a cell phone in relation to a tower. Another Georgia case from 2014. A lot of case law here. You notice what we don't see here? Bold, underlined, caps lock screaming. And I don't know if we're going to get that. Maybe, but probably not because these are sane lawyers. Third, the introduction of computer-generated evidence similar to these cell phone analyses has also been approved without the need for expert testimony. In a recent Fifth Circuit decision, the court held that expert testimony is not required to introduce the information from a cell bright extraction from a cell phone. A trained technician who testifies that he operated the apparatus properly can explain what he did and the results obtained without being able to explain how the cell bright extraction works. Here, Middlestat, for Trump, he used CellHawk instead of CellBright. His testimony will mirror, though, the testimony offered in Georgia courts and courts throughout the country. When one uses a cell phone, either by texting or calling or receiving a call, or by simply having a cell phone on so that it is constantly pinging, a cell tower nearby will receive and record the ping. This evidence simply shows the approximate location of the cell phones based on the nearby cell towers. And so they say, Your Honor, Judge McAfee, our witness, Middlestat, his testimony will be precisely what he described in his affidavit. Most importantly, Two dates. On September 11th, Wade's phone left the Doralville area, and it arrived within the geofence located on the Dogwood address at 10:45 p.m. It's Fani time, booty call. The phone remained there until September 12th at 3:28 in the morning, at which time the phone traveled back directly to Nathan Wade's residence. The phone arrived in East Cobb at 4:05 a.m., and records demonstrate that he sent a text at 4:20 to Miss Willis. I'm home safe, baby. So good to see you. Sleep well. And that's the game. Goes over 10:45, does the old indictment of Fani, and he's back in home at 4:20 in the morning. Good night, sweetie. On November 29th, same thing. Wade's phone was pinging on the East Cobb Towers near his residence. November 29th comes in. She's feeling a little lonely over there. You know, I had a stressful day, not doing anything, celebrating my 100 days. She sends him a phone call following a phone call from Miss Willis, more accurately, from Mr. Willis's phone. So is that her father's phone? At 11:32 p.m., and while the call continued, his phone left the East Cobb area just after midnight and arrived within the geofence located at her address, 12:43 in the morning. Fani says, I need some Nathan. He comes over there, and the phone remained there until 4:55 a.m. Clearly a Fani call. That's all. He's just going to explain that. That's all. He's not going to offer any opinion. He's not going to testify as an expert. He's only going to be a summary witness explaining exactly what the records show. Now, the prosecution will surely point out that nobody knows what was happening in the house between midnight and 3:28 a.m. Yeah, what was happening in there? Nobody knows what they were doing. They could have been working on legal filings, okay? And nobody knows what happened between midnight and 5 a.m. on November 30th. Now, Middlestat does not claim to know either. He doesn't know. The phone wasn't recording anything, fortunately for us, but it was there. Now, neither does President Trump or any other defendant know in this case. We have no idea what was happening. Only two people in this whole wide world know. Nathan and Fani. And they are certainly the ones who should testify and say exactly what was happening on those occasions, so nobody in this world will complain about improper speculation or improper efforts to distort the truth or nefarious contacts with the media. Just come out and explain it, Fani and Nathan. What were you working on? What kind of memos were you working on? Having late night talks over a cup of tea? Yeah. All we have heard from Wade and Willis so far has been they did not have a romantic relationship until 2022. Yet it's highly significant that the state's response that we just read did not even attempt to challenge the evidence regarding the September 11th and 12th date or the November 29th and 30th dates. Did you notice there was no denial in that at all? They just threw other dates in there, like April. The defendant's business record evidence is admissible, and Middlestat stands ready to testify as reflected in the affidavit. Now, this evidence is admissible because it is extrinsic impeachment evidence that's relevant here. They argue that this evidence is improper extrinsic evidence, but this is just simply not right. Yeah, it's true that Rule 608B limits extrinsic evidence, outside evidence, when the primary evidence is nothing other than evidence that is offered to prove a witness's lack of credibility based on some prior bad act, right? It's broad. But this evidence here, this cell phone evidence, it is not being offered for the purpose of showing a prior bad act that impeached Nathan's credibility. There is no prior bad act. Thus, the prohibition on extrinsic evidence has no applicability here. You're citing the wrong rule, government. Instead, the rule that is applied here is this one, which provides in the broadest terms that a party is entitled to offer evidence that contradicts the testimony of a witness, which is exactly what this is. the witness in this case, both Wade and Willis, they testified that their romantic relationship did not begin until March or April of 2022, and that they had never spent the night together prior to the spring of 2022. Two lies. Now, the evidence offered by the defense will refute this testimony, and it's all permissible under the rules. They say, the state's response also fails to factor in that the more extensive data for the two dates, including the cell hawk, those two dates, including the animated map, which details every cell tower hit along the route of travel, it demonstrates that Wade's phone traveled to and remained at Yurti's condo during the geofence at times when the clubs, when all the restaurants, when all the Porsche experiences are not even open for business. Are they open at 3 in the morning? Nor does the state choose to inform the court that this is the same data that they routinely rely upon for their convictions in their own prosecutions, and thus any suggestion that this data is unreliable is disingenuous at best. They also try to equate this evidence to specific bad acts of conduct that was used to try to impeach Bradley. But this evidence is not the same character of evidence. It is not specific acts of conduct of Wade or DA Willis at all. Right? So Bradley, they're saying he, assaulted 2 other people, employees and others. This is not that at all. This is just, spreadsheets. It's all just spreadsheets from AT&T that somebody analyzed. So the breadth of this cannot be overstated. Impeachment of Nathan by disproving facts that were testified to by a witness doesn't need to occur on cross-examination of the witness. If the witness testifies to a certain fact, and the opposing party may impeach that witness simply by calling another witness who offers contrary testimony about the fact at issue. Impeachment may also be achieved simply through the introduction of a photograph. In Kelly, another Georgia case from '98, that defendant testified he never walked around the house nude. No, never, ever, never, never, not once, never nude. The opposing party was then permitted to impeach the testimony. They just showed a nude photo of the dude in his house. They're like, what about this time? He's like, oh yeah, forgot about that one time. And that was during the punitive damages phases of the trial and when the witness expressed remorse. The plaintiff was permitted to introduce a letter, another case. They were allowed to introduce a letter threatening litigation. And so the impeaching testimony may simply reveal that the witness's version of events is less likely to be true. The defendant was charged in this other case with aggravated assault with an intent to commit the R. He offered a hospital record of the victim that revealed she had cocaine in her system. The Court of Appeals held this impeaching evidence should have been admitted because the evidence supported the defendant's version that she was the aggressor. She was hopped up on cocaine like Hunter. In short, the impeachment cell phone evidence can be introduced simply by offering the records that demonstrated that they spent 2 nights together on dates that contradicted their version of events concerning the inception of their romantic relationship, and in contrast to their testimony that they never spent the night together at the condo. Now, the defense does not propose that the court compromise by simply admitting the records into evidence. No, the preferable method would be to allow our witness, Middlestat, to testify and to be subject to cross-examination by the state here. They say the evidence is also admissible as a relevant substantive evidence tending to show that there was a close interrelationship between Wade and Willis during a time that Willis was living at the condo. Remember, Wade was hired on November 1st, and they both told us under oath that no relationship started until 22. Now, the breadth of the Georgia law is also compatible with the basic philosophy of the evidence code, which codifies the definition of relevance as defined, saying relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence more or less probable than it would be without the evidence. So if any bit of evidence helps you decide even a little bit, it's relevant. Given the testimony of Wade and Willis, they testified that they never spent the night together in the condo. The evidence, the actual record evidence, is not just an opinion or speculation. It proves that while talking on the phone with Willis, Wade drove from near his house to a location near her condo, if not exactly to her condo, at midnight, where he then remained there for 5 hours, not once, but twice in 2 months, that qualifies as relevant evidence, if not presumptive proof of the fact that they did spend the night together on those 2 occasions at the condo. And to be clear, presumptive proof is not required as a precondition to the introduction of this evidence to prove a point. Evidence is relevant under the law when it's low, okay? When it tends to make a fact that is of consequences more likely. Very liberal. It's a very low standard. A lot of stuff comes in. So the cell phone records that show that they were talking on the phone and then ended up at a location near or at her condo for 5 hours makes more than just one fact more likely than not. 1, they spent the night together on those 2 occasions, and 2, their romance began before Wade was hired. So that's a lie. That's a lie. And one more fact, also more likely true than not, neither of them testified truthfully at the hearing on February 15th. Clearly true. And so, therefore, President Trump respectfully requests that the court rule that the cell phone evidence of Nathan Wade is admissible, permit the defense to call Middlestat as a witness to testify about this, and the use of the software called CellHawk as reflected in the affidavit, and to admit all of the other exhibits attached as evidence in this case, signed by Steve Sadow and Jennifer Little. Shout outs to both of them for doing some awesome work here and served back on the government. Fani is not happy about this. So they've got some very good case law. Now, even just comparing and contrasting these 2 filings, what do we see here? Did you see any bold, capitalized, underlined, screeching rants from Steve Sadow? No, you didn't. You know what else you saw here? Some case law. We actually had some case law here. We have Goodwin versus State of Georgia. We got Bowen versus Bowen. We got Fowler's in here. We got Kelly versus State, Martin versus State. Bunch of Georgia statutes are being cited. A lot of evidence to support their claims. What we saw in the prior filing was not much of that. We saw very little case law throughout this entire thing. They referenced Daubert, which they didn't even use that appropriately. They're trying to shove this guy in as an expert, but he's not. So they use some case law that applies to Daubert, but it's the wrong area of the law. So very good filing from Trump and his defense trying to get these records admitted in. And I'm very hopeful the judge ultimately allows it. I think it should be allowed. The judge is facing a situation where the county attorney and the special prosecutor lied directly in his courtroom and doubled down on it multiple times. And the cell phone evidence is just evidence that they can explain. If they think that it is so erroneous and so problematic, they can explain that. Come out and explain what they were doing, whatever legal brief they were working on, and why that didn't match up with their testimony. Nobody's going to believe it. Now, they are coming back here for summation arguments on Friday, my friends. And so we're going to be covering that live. Make sure you are subscribed. We are not going to be missing that, and it's going to be juicy. But there will be some more litigation that happens, right? The judge is probably going to issue an order on this, so we know whether or not they're going to be reopening some evidence or whether Middlestat will have the opportunity to testify on Friday. We also know that there was an interesting event today because Terrence Bradley was apparently meeting with the judge today, Judge McAfee, to talk about the difference between bro talk and pro talk and whether Terrence Bradley can be another witness who's going to provide even more evidence that Fani and Nathan lied. Remember, Robin Yurdy, who was a former employee of Fani Willis, said that their relationship started way before they said it did in 2022. Terrence Bradley may be able to come out and support that claim as well, because he, although was Nathan Wade's lawyer, he was also his friend for a long period of time. And so he might have some bro talk that is not pro talk, that is protected by attorney-client privilege. And if he can come out and explain that to the judge, now we've got just a whole boatload of evidence. We've got Robin Yurdy, we've got cell phone records, we'll have Terrence Bradley, and we'll have all of their other inconsistencies and lies that they told us on the stand. And it will be a damning case for them. One that I think that Judge McAfee will not be able to overcome. Here is what 11 Alive says. Terrence Bradley was there. She was outside the courtroom today. Here's what it sounded like.
Aisha, Judge Scott McAfee, he will meet behind closed doors with Special Prosecutor Nathan Wade's former attorney, Terrence Bradley. Now, this will happen behind closed doors, so we won't see the firing and compelling testimony that we saw at the initial hearing. And this is all as defense attorneys are questioning when Nathan Wade and Fani Willis started dating. Special Prosecutor Nathan Wade's former attorney, Terrence Bradley, will meet privately with Judge McAfee as defendants in the election interference case continue their quest to get DA Fani Willis and Wade disqualified for having an alleged relationship before Wade's appointment to the case. Attorneys for the defense believe Bradley can prove Willis and Wade's romantic relationship began earlier than what Wade and Willis testified. Bradley took the stand during the initial hearing but invoked attorney-client privilege and said he cannot speak to Wade's relationship without putting his law license at risk.
Advised by the bar that Rule 1.6 of confidentiality applies and that I cannot reveal anything that I saw or learned.
Wade attempted to block additional questioning, arguing private questioning by Judge McAfee may unlawfully compel Bradley to break attorney-client privilege. The timeline of Wade and Willis's relationship has been the main point of focus for defense attorneys.
Because they lied.
While Wade and Willis insist they started dating in 2022, lawyers representing former President Donald Trump claim new cell phone evidence can prove otherwise. Attorneys say those records reveal at least 35 occasions in 2021 when Wade's phone connected to cell phone towers near Willis's condo in Hapeville for extended periods of time. In court, Wade says any cell phone records suggesting he was in Hapeville would be wrong, and that his visits to Willis's condo were for business. And the DA's office says the records do not prove anything relevant and should not be considered as evidence. Now the judge must rule whether those cell phone records can be used as evidence in disqualification proceedings. Meanwhile, the next date that we're looking towards is March 1st, and that's when Judge Scott McAfee has set that date for disqualification arguments. All right, and so we're going to obviously be here covering that, my friends. So very interesting response from Fani. Caps lock, bold, underline, screaming. Ah! The poor guy doing the typing on there, getting abused in her office. Make it bigger, make it more aggressive. Fani's very upset about this. And so we're going to be here covering this, my friends. There's going to be a lot to get to as this unfolds. I imagine we're going to see some new filings, probably some more motions drop between now and the hearing on Friday. We're going to be here covering it live. So we'd love to have you join us. Thank you for hitting that like button. Thank you for subscribing. Thanks for bringing over someone to come and join us here on the show. We go live 5 days a week here, watching the Watchers live, and we're very grateful to have you here and with us. We also have some great links down in the description below. If you want any of the PDFs, go to robertgovea.com. We post all of the show segments up there along with the PDF so you can download it. We have our newsletters there. We have our merch shop is over there, and we'd love for you to check it out. We also have some events coming up at watcherlodge.com, free events. We have Political Zen Wellness coming up, and it's going to be amazing. So come and join us, all free, watcherlodge.com. And we'll look forward to seeing you back here, my friends, on this case and all the other Trump prosecutions right back here on the next one. All right, my friends. Well, that is it for us on the day. We covered some good ground. Fani raging over the cell phone records and Trump moving to dismiss the Presidential Records Act, based on the Presidential Records Act. And we're just warming up on those. We got some new filings. We'll talk tomorrow about void for vagueness, which is another motion Trump submitted to dismiss the classified documents case. But now, my friends, let's hear from you and see what you have to say about all this. We are going over to watchingthewatchers.locals.com for our members only after party as soon as we're done here. And I'm very grateful for all your support and donos here, my friends. Thanks for sending these in. We got Maureen B is coming aboard as our newest member. Welcome aboard, Maureen. We got Tony Hayes bringing in 5 new membos. Coming in, Old Drill Sergeant Welshie's here. Richard C., Holly K., Judy O., and Catania Mama Italia, all in the house, courtesy of Tony Hay Munkets. Thank you very much, Tony Hay, and welcome aboard, my friends. Roger N. is here, bringing in Knowledge Tracker. Welcome aboard, and thank you, Roger. We got Show Bizzle. Says, my favorite part of the day, Rob. Thanks for all you do. You know, Show Bizzle,
It's mine too. Little secret. I love hanging out with you guys. This stuff is wild. Crisis at the Border on YouTube says, if Nikki is the only one left on the ballot, can they put someone else up at the convention? I think so, honestly. I mean, I don't know the convention rules, but I remember hearing that at least the Democrats can. I don't know if the Republicans can, but James Carville said the Democrats could do it. I'm sure there's a mechanism for it. If something else happens, there's a mechanism. I don't know what it is specifically, but hopefully that doesn't happen though. Show Bizzle says, hey, what's up, Show Bizzle? This old guy says, along with Trump's election, the DC circuit could just move to Sheridan, Wyoming. Yeah, but that would be terrible for the poor people of Sheridan to have to deal with DC circuit. We could just get rid of DC, Good to see you, this old guy. Show Bizzle says, let's go. Good to see you, Show Bizzle. And we're going, baby. Thanks for joining us as we do. Captain Jack Sparrow on Local says, good afternoon, watching the watchers. Does he have a voice, Captain Jack Sparrow? I don't think I could do it even if I tried, but thank you, Captain. Tara Rayner says Ukraine hired a hitman to take out Tucker in Moscow. I saw that story. As we were just flipping through, as I was flipping through final show prep, I said, wow, that's pretty interesting. Roger says, can you brief us on the Chevron case sometime? That's a possibility, Roger. It's an interesting possibility. I was trying to think if I could fit that in somewhere. But I'll keep it in mind. Thank you, Roger. Thanks for the dono. Hey, betrayed by corrupt scumbags is here. Been a membo for 15 months. Amazing. Betrayed by corrupt scumbags. Almost two babies in the house. We got Cindy Banks says, Rob, Breitbart dropped 2 bombs today on Fani. Said that Nathan Wade led Fani's transition into office. Nathan was hiring and firing. He was an outside contractor. Whistleblowers went to Breitbart. And Biden at admin planted an operative in Fani Willis's office to target Trump. That's amazing, man. That's amazing, Cindy. Maybe we'll have another update on those tomorrow. Breitbart doing some good work over there. Thanks for flagging those. Economath says, I hope Judge Cannon holds that Trump's retention of the documents is a legally a constructive declassification. Yeah, I think it's another way to do it. I think that's what it is, right? Trump may not have filled out a form, but the order was the movement of the boxes is the analog, and it's based on the Clinton precedent. Sorry, they did it with Clinton. This old guy says Pelosi's January 6th committee will ultimately be proven to be the most damaging thing done to our republic since the Civil War. NARA only asserted its claim to presidential records as a result of the committee, and 100% of the lawfare by the DOJ and the rogue state DAs occurred as a direct result of the committee's legally defunct Trump derangement syndrome. Great comment, this old guy, and I think you're right about that. It was the opening, Trump in general was the opening of the floodgates that enabled a lot of this, right? They could rig elections to save America. They could censor us to save America. They could prosecute political opponents to save America. Right? It's all that garbage. Highland Bull says, Rob, do you agree that the Trump raid was because the FBI and the government is trying to get documents back Trump has taken that implicates them all? I don't know the details on that exactly. I know there is a binder that they were fighting for. And in fact, that shows up in one of our filings. I don't know that that's the only reason. I think that they also just want to prosecute Trump. They just want to criminally charge him. It's probably a bonus, though. B-Man says the Dems are already starting a new Russia narrative. 100%. We got clips from Psaki. We got clips from Pelosi. They're all saying it now. And if you vote for Trump, I think Swalwell said that. If you vote for Trump, you vote for Putin. That's where they're going to go. Glocky says, it's breaking now that the CIA in Ukraine tried to assassinate Tucker. Not a surprise. Apparently, Glocky says Jack Smith is misleading the court, according to Julie Kelly, who's incredibly smart and always right, much smarter than Jack Smith. Shout out to Julie Kelly on X at Julie_Kelly2. Glocky's here sharing. We'll leave that one. Glocky shared this one. That moment you realize you should have thought before running your mouth. There's another one from Glocky. It's a good Fani meme. We got Roy says, I can now see why Judge Cannon insisted to separate the filing separately. As a single filing, it would have given Smith the opportunity to hide behind some of the issues with a single response. Now, each filing must go through the process in the lower court, then appeal to the state Supreme Court before finally getting to SCOTUS with a stay at each stage. I much prefer the separate filings, much prefer, rather than a 200-page, omnibus motion. Glocky says, we'll leave that one. Barb, thank you for those. Some of them are a little spicy, so we just leave those on locals. Barbaric Brit says, I swear they're all just begging to be violated. Oh, gosh. The prosecutors? Yeah, I don't know. Good to see you, Barbaric Brit. Yeah. B-Man says, I have zero respect for Fani because I think she knows what is going down there as concerns last presidential election, and someone who puts people through this for partisan reasons is evil. Yeah, I mean, she's just a corrupt actor for the opposite side. So, yeah, is she investigating, electoral problems or no, of course not. No, she's going on cruises with her boyfriend. Rob says, so if Trump gets screwed in the documents case, can Judicial Watch get Clinton's tapes? I'm sure they're long gone by now, Rob, but no, only Trump gets screwed. Okay, that's all. There's no equal standards here. It's not like it's not like guess what's happening now, Bill? No, of course. Only Trump gets punished, no one else. We got this old guy says, Fani took Wade to Aruba for his birthday. She should have just given him $14.95 Faraday bag for his phone. That's a good one. Yeah, look, if you're going to be grifting $1 million and engage in a scandalous affair to prosecute political opponents, at least turn your phone off. Come on. Knox says, happy Monday, all. I am amused that the best Miss Big Fani's team could come up with is scheduling orders. Yeah. The judge states he may reopen discovery at the close. Does she think this is civil or something? Yeah, it's funny, Knox. I don't really know what they were talking about. And they stole our phone records. He's like, we got a subpoena, weirdos. Calm down. Wasn't Hamilton a slave owner? Says Knox. How racist of her. That's true. Does Abate know that he's quoting a slaveholder in his filings? I wonder if Fani knows about that. Maybe she'll bold, underline, and exclamation point his butt. Pinochet says, sorry, the state has the monopoly on violence. The state has all the power, and it's impossible to ambush the state, even if the state lost all of its limbs. Yeah. Yeah, lost all of its limbs. No arms, no legs, on the floor in the front door. Matt, right? All right. Barbaric Brit says, question, what was you doing at Fani's address on these dates? Answer, I was making a deposit. It takes half an hour for the little blue pill to work. Oh, gosh, Fani and Wade, sex jokes. Chubby says, it's funny, but it's just those two. Chubby says, if we've learned anything from the J6 trials, it's that the court district's rules are only mere suggestions. So Fani should be shut down like Chutkan does to Trump every time the rules are brought up. Good to see you, Chubby. Glocky says, Rob, this is insane if proven true, but at this point, I would believe it. They have told us what they think of Tucker. Yeah, there's a dude apparently who is admitting to the whole thing. Says, yes, I was paid $4,000 to go eliminate someone. Turns out that someone was Tucker. Flagpole guy says, Fani's dress created a mess. Nathan's marriage wasn't the best. She laid her head, her money under her bed. The two lovebirds took a trip instead. Trump comes along, enriched their song. Now everyone else is the lying ding dong. There we go. So that's a nice poem from Flagpole guy. Trump 2024 on the flagpole. That's a beautiful poem. I think it should be published somewhere. I love it, Flagpole. Knox says, the judge stopped the fight before Bradley was torn to shreds beyond any hope. It was a mercy call. Yeah, I totally agree. And there was no need for it. All of that external stuff was irrelevant to the, yes, okay, his credibility, it was done. He was already dead. Okay, stop. He's already dead. Chubby says, only bold, underline, in all caps, basic font size, no italics. Clearly they weren't that serious about this filing, such amateurs. Yeah, they could have increased the font, you're right, and italics, although our eyes would have started to bleed at that point. Geg says, okay, so time for all future cell hawk evidence to be challenged in Fulton County? Totally. Yeah, so this is what I was talking about with that domino effect. Great question was, what happens if Fani goes? Do all of the other cases go? And this is like one of those things. If they come out and they say, all this evidence is terrible, defense attorneys are like, great, my case is literally built only on cell phone evidence. So I'm going to use their filing in my case, and they can come and explain it. Or give us a better plea deal, or whatever. Good to see you, Geg. Hey, Knox says, I have only used bold and caps when doing a heading, there you go, in an appellate brief, but never in the brief. Geez. The mass murder was the massage parlor case. Okay. Yeah, as a heading, that's fine, but not screaming about racial and gender bias. Like that's Fani pounding the table literally. Facts Matter says, yo, you gotta go, Fani. Yo, Fani, yo, you gotta go. Chubby says, someone should explain the DEI hire that these are actual official government documents and not a middle school book report. Yeah, it's not a Facebook post, okay? You can't be putting your rants on, you're not on Facebook. Calm down. Quarter Native. Look at this new fur baby in the house, a new addition to the Watcher fam. What a very handsome pup. Looks very cozy, nestled at home in his new home. New fur baby in the house. Shout out to Quarter Native. Thanks for sharing that with us. Hope you're having a ton of fun. Looks like it. Looks like you are. Roy says, is it any wonder she's only in the office at 11:30? She's been awake all other nights on other things. We got Debbie says, celebrate my Fani Day. My Fani Day. This is too much. Celebrate my Fani Day. Oh, right? It's so funny. Celebrate my Fani. You better come with a nice gift for her, okay? It's been 100 days. It's been a lot of work. She's been on cruises a lot. So she's tired. Odyssey is a case management package. And she's learning how to use it, huh? That's good that she learns how to use it. Glocky says, Rob, you in the chat should be ashamed of yourselves. Picking on a woman of color who is somehow worth $8 million, who is just trying to save my democracy. Have you no decency? That's pretty much their reply. Totally. It's like we're under attack and by Trump, and now they're attacking us even further. And so they just pound the table in bold and underlines. Beezy says, Fani claims she was elsewhere. So Nathan possibly had a key. And that would explain why Merchant claimed cohabitation in the condo. Yeah, I'm sure the defense has a lot more than they're even letting on. Pookie's Ma says, I just finished watching the morning show and y'all have me second guessing my email signature. Mine is big, bold, and beautiful, baby. Well, sometimes they're appropriate. Pookie's Ma says, shout out to my fellow South Floridian and new member, Lane. Welcome to the best political analysis channel in the world. And Pookie's Ma, shout out to your signature line. I'm sure it's perfectly appropriate. Perfectly appropriate. We were just ripping on Fani's because, you know, she's a corrupt prosecutor hack. But, you know, I'd say I'd like, you know, unique email signatures. You know, sign your emails loudly, Pookie's Ma. Go big. We got Todd says, do you think Anna is, and welcome, I want to say welcome to Lane as well. Todd Scott says, do you think Anna is dripping enough Easter eggs to implode Fani's case out of spite? I don't know. I think Anna's a team believer, man. I think she's a true believer. She's a prosecutor through and through, and she was wanting to save Fani. And now it's out of her control. Todd Scott says, Fani abused cap locks more than any sovereign citizen ever did. That's true. You know, they indicted some people for illegal memes and things, and Fani's screaming at the court. Maybe there'll be some recourse. Good to see you, Todd. Some guy with cancer. Man, I hope you kicked that. Says the prosecutor in the filing got smacked by GA Supreme Court for lying about a deal between the state and a witness. It's called Georgia versus Thomas. I've seen some rumors about that. Yeah, the Abate guy may have gotten disciplined or gotten in some problems there. BH Williams says, who is Mr. Willis? If it's her dad, how did she get his phone, especially if he claimed that he never met Nathan? Yeah, and what was her dad's phone doing at her condo when he didn't go there? Very curious. Dolphin Fan is the man, is bringing in new membos, including Cindy's coming in, Gail G. That's hot air. Conservative Mama's coming in, and this one is from Yvonne, also coming in. Yvonne L. joining us as membos, thanks to Dolphin Fan is the man on the YouTubes. B-Man says Gateway Pundit has a story about the lawyer pulling strings in Atlanta for Biden. I'm going to look into that one too. That sounds like a very juicy one. Daryl B, been a member for 2 months, says, let's cross the phone and the billing to the country, to the county. Cross-reference it. I'm sure they have so much more details that they're not sharing with us yet. Tony Hay is bringing in more membos, 5 of them. Eagle 80, Aaron's here. Falcon H, Sargoy Dopamine's here, and Carol R, all coming in courtesy of Tony Hay Munkett. Hey, Debbie says, note to self, do not take cell phone to booty calls. Good advice. Good advice. Just keep it all under wraps, you know? Hey, UMD says McAfee has ruled Bradley has to retake the stand via X. Whoa, yeah. That's amazing. Okay, so that's going to be a lot of fun. We'll see when that comes out. We got E. Harris says, in honor of my friend and fellow Army NCO, Ilya Chiagapin. Hey, what a nice shout out. And says, thanks, Rob, for helping me focus on something else. Man, good to have you here, E. Harris. We're sending some love your way, and we're pausing for a moment in honor of Army NCO Ilya Chiagapin in the house. E. Harris, thanks for that, my friend. Stay strong, brother, and we'll see you back here tomorrow. Linda H. here says, thank you, Robert, for all your hard work, and I mean it. God bless you. Linda, God bless you right back. Thank you so much for saying that and such a generous donut. I love being here with you. We're doing important work together. We're living through a historic journey together, and I'm grateful for our time together. So thank you, Linda. Thank you really much, very much for supporting us. Jennifer says, thanks for another great show. Rob and the Watching the Watchers fam in the house. And thank you, Jennifer, for being a membo and supporting us in our work. We got Gun Faces here, says, why is Fani crying about proof? Doesn't the Trump side only need to show the appearance of impropriety to remove her? Yeah, it's definitely not like a beyond a reasonable doubt standard. So we're asking what the standard is. Like, do you need like 100% proof here? Or is it preponderance of the evidence? Is it clear and convincing standard? Is it beyond a reasonable doubt? Is it a lower standard? What is the standard? And we're going to see what the judge says about it. But yeah, an appearance is a big problem. That's what we want to avoid. We got Cindy, a membo for 6 months. Welcome, Cindy. Thanks for being a membo for 6 months. Amazing. Bruce Wayne, Batman's here. Fani is a 3-pill kind of a gal. I don't really know what that means. Yes, I do. It just took me a minute to get it. 3-pill kind of a gal. Yeah, you're gonna need some fortifications to get through that one. Hey, Jesser Bob says, all this talk about Fani has made my Fani hungry. Time for some porterhouses, and yes, Rubo's salt. Oh my gosh, look how delicious this looks. Oh my gosh, this looks so good. Oh, so good. And you know what's back there, my friends? You see that bottom of that? See the bottom, this right here? I almost pointed at the screen like you could see it. I almost pointed at my screen. Right here. That's Rubo's Salt Shop. And man, this is some good stuff. And there's no, affiliation or anything here, but go to rubossaltshop.com. You're going to get yourself some of this really amazing salt. And it's delicious, okay? I don't know what kind of salt you're using, but if it's, garbage table salt you don't think about, get some real good salt. It's called Rubos, and they're great people too. So you can, of course, support them, rubossaltshop.com. Look, he's even putting it on his porterhouse. Delicious. It's going to taste much better with that salt. Look at that. There it is, the Rubo Salt Shop. Woo! That's some good stuff, man. That is going to be delicious. Red One says, tomorrow is Bradley's testimony. Oh my gosh! It's going to be a Tuesday miracle. All right, we're going to be here live when Bradley's testimony is live. It's going to be amazing. Thank you, Red One. We're going to be here. Alma Lopez, welcome Alma to our newest membo on the stream. We got this one from a Pink Rose, says, breaking, judge rules no attorney-client privilege for the special prosecutor. He's going to have to testify. Whoa, a Pink Rose. And that's tomorrow, apparently. We're going to be here covering it. I don't know what time it's starting, but we're going to be there. Gunface says, remember the defense asking Fani and Wade if they ever met in D.C.? I bet they've got evidence on that one as well. Great point. Yeah, great point on that one. There might be more there. We'll see. Okay, my friends, thank you so much for sending those in. Gunface sending that last one in. Let's say hello to our friends on X very briefly, and then we're going over for a short after party at watchingthewatchers.locals.com. And we got 32 viewers over on the X. Amazing. Oh, hey, Paul Minot, our meme smith is here, says they see all caps. Wait until they see the underline and the bold. Genius! Underlined and bolded, courtesy of Paul Minot. We got Sandy Beach. What's up here? Says, your communist TV doesn't like us. It's been freezing and giving us the spinning circle. Fred Pedamonte saying, I find it rich. Fani's mad she didn't get all the phone info. What's a grand jury? A secret court that can lie? Rob's not working on Rumble. Are we not working on Rumble today? I think we are. Hopefully we're working. Over there, we got shout outs. Oh my gosh, look at this dude. Richard Wadsworth, amazing. Says, I love my hat. Richard, you look very good. Man, it's a stylish hat. My other one's over there. That color I usually wear to the gym. This is the other one that I wear. Man, good to see you. You're looking sharp there, Richard. This is our Watcher logo. It's Lady Justice, Lady Liberty. It's the unbalanced scales of justice. We have the sword to cut through the bonds of ignorance. We have the shield to defend our community and our communities. And you look amazing, amazing. Richard Wadsworth in the house. So great to see you. We got Al Holman. We got George. We got Alfred. We got Crypto Nerd saying Texas is in here. Horatio, good to see you. Dirty Coins. And Matthew Reese, all in the house over on the X platform. Very nice to see everybody. We are running over to watchingthewatchers.locals.com for our members only after party. And we'd love to see you over there. Before we wrap it up, we want to say thanks to our mods and our meme smiths, our friends, Vienticus Prime, K Bean in the house, Just Cause, Playin' Hooky, our friend Ronnie Cole, Zulu's joining us, Beyond Geo, Zach Nichols, John Allen, Janak. We got Dog Digger, Donut Mind Me, and others helping away. Thanks to our mods and our meme smiths. We got Sleepy Dog Lee, Nathan N810, and Geegum Geegum. And we're grateful to have everybody join us and mod down the fort for us and keep things nice and orderly. Big shout outs. Red One is bringing in Xavier L, Dust in the Wind, Colette D. We got Mark J, Texas Guitar Gal, Lao Zhu, Don D, Very Scrog is here, Beautifully Inappropriate, and Karen O, all in the house, courtesy of Red One. Thank you, Red One, for joining us. And Tony Hay, I think, brought in some others. Dire Gnome, Richard G, Irene A, Villainy F, and Mary P, all coming in courtesy of Tony Hay. And very grateful, man. We got some good new members today. We're very excited to have everyone here and joining us. Sandy says, I loved watching Trump attorney troll Fani saying she needs to get back on the stand, knowing the DA office wouldn't even let her back on the stand for Cross. No doubt about that. Yes, indeed. Okay, so my friends, that is it for us on the day. We are going over to watchingthewatchers.locals.com for a little bit of a members only after party. We'd love to see you there. We have streams in the morning and streams on Saturdays, and so come see us tomorrow morning, if not tonight. But that is it for us on the day, my friends. We are going to be back here for Terrence Bradley. Apparently that's tomorrow. I don't know what time it's going to be, but I will schedule it tonight so that it's on deck for tomorrow. So come back here in a few hours and we'll have whenever it's scheduled, we'll have it scheduled. So my friends, that is it for us on the day. We will be back here tomorrow. Thank you for setting your notifications so you don't miss us. It's going to be another day in Fulton, and we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends, a beautiful evening. We'll see you right back here tomorrow. Bye-bye.